attorney, do you practice immigration law? Or if you are a GAL, do you encounter many undocumented or documented people in your work? You can raise your hand. No? Nobody? Okay, so good. So we'll have a lot of learning today. I will take questions as I'm presenting, just to resolve any doubts while you're hearing the presentation out. So without further ado, we'll get started. And this applies for the people online too. If you have questions, please voice them out to me. So Justice for Our Neighbors Nebraska is a nonprofit organization based out of Omaha, Nebraska. However, there is a satellite office where I am present in Lexington, Nebraska, inside the HHS or Lutheran Family Services office that you've seen. We office share there. We provide free legal immigration services, education, and advocacy in the state of Nebraska. We serve people who cannot afford a private attorney and need free legal immigration services. So Justice for Our Neighbors actually got started back in the mid-90s, and that's when the Methodist Church partnered up with Justice for Our Neighbors, and because of the lack of immigration attorneys in all of Nebraska, Washington, D.C. attorneys would come here and do clinics, so they would see a mass amount of people and then return and do work from Washington, D.C. and mail things in and out, which is similar to what we do still today. So we have 4 locations that we target: Lexington, Grand Island, both of those are the ones I'm in charge of, and then there's Crete and South Sioux City under our Rural Capacity Building Program. And those are the 4 target communities that we face. And then Omaha JFON office obviously takes Omaha cases. So today we will go through, and sorry the slides are not going to be the exact same. I did want to change it a bit to do the executive orders last instead of first, because then I can teach you a little bit about the terms that we have, and then you'll understand me a little bit better if I do it that way, I think. So starting off with the immigration system, we will talk about members of our community, some words and terms that we can change, categories of relief, family-based immigration, additional hurdles to overcome, grounds of deportability, U.S. citizenship, and lastly, questions, but I do want you to throw out your questions if you have it in between the session. So starting off with the U.S. immigration system, which looks simple enough, right? It's actually very complicated, and as you can see, the arrows, we have many different organizations that we deal with and different agencies, So to start off, we all know the basic U.S. system, right? There's an executive branch, legislative, and judicial branch. Executive enforces the law, legislative makes the law, and judicial interprets the law. So in immigration law, we primarily deal with the executive branch, and those 4 branches that you see there are Department of Homeland Security, Department of Justice, Department of Secretary of State, and the Health and Human Services Agency that we also deal with. So I will explain some of the terms because these do relate to what we will talk about later on. So under Department of Homeland Security, which probably, aside from the Department of Justice, are the 2 main departments that we deal with in immigration law as immigration attorneys and also as undocumented people and documented people. So starting off with ICE. Up top here, ICE is Immigration, Customs, and Enforcement. You usually hear about ICE when you hear about raids. Raids usually occur when ICE agents come to an employer with a warrant and detain a mass amount of people who are undocumented and sometimes documented. And then under ICE, there is CBP. That is the agency called Customs and Border Patrol. You encounter them at the border, either Canada border, Mexican border, but also at the airport. So when you go to the airport, you likely see there's a lane for U.S. citizens, and then there's a lane for non-U.S. citizens. CBP is located in that lane. And then under CBP, well, not under CBP, but within Department of Homeland Security is USCIS. USCIS is the United States Citizenship and Immigration Services Agency. So this is the agency that processes many of our applications that we submit. When we talk about petitions for family relatives, renewals of work permits, DACA applications, these are processed by USCIS. And then under the Department of Justice, the next branch, we have our own little immigration court system, just like we have in the States. So at the bottom, you see immigration judge. Usually when we go to court, it's before immigration judges in Omaha, Nebraska. That is our nearest, well, from North Platte, I guess we're in the middle. So that is our nearest court in Omaha, from Lexington and Grand Island, where I practice. And then if you lose at that level, you appeal to the Board of Immigration Appeals, and they hear the appellate court. That's our appellate court. The BIA is also in charge of assigning BIA representatives, or you've probably heard of Department of Justice representatives. So those are non-lawyers that can practice immigration law, but and only immigration law. I'm sorry. And they can be partially or fully accredited. So the BIA made this position because more than half of the people that go to immigration court do not have an immigration attorney to represent them. Consequently, the BIA created this position in order to meet that gap or meet that need and split it up into two. So fully accredited representatives can even represent undocumented and documented immigrants in immigration court. However, partially accredited representatives cannot, and they process usually the applications that are then turned into USCIS. So like renewals of work permits, renewals of residencies, DACAs and citizenships, those type of applications are processed by USCIS. And then under the Department of State, you see U.S. consulates. These are located abroad and process a lot of the visa applications that for immigrants to enter the United States. Also non-immigrants, so if you're applying for a visa from abroad, you go through the U.S. consulate. Then there's Health and Human Services, which is under them is Office of Refugee Resettlement. Probably self-explanatory, they do resettle refugees, but we also encounter them within the United States with children who come from abroad. They hold children, and Mindy will talk about this more in detail, but this is the first agency that those children encounter before they are then released to a family relative or someone that can care for them. Then under the judicial branch, that's our normal court system, district court, court of appeals, Supreme Court. So if you lose at the BIA level, you can still appeal to the court of appeals. That doesn't occur as often, but it does happen. So now splitting up our community members. So we're split up into two. Into U.S. citizens and non-U.S. citizens. So one thing I always say is don't judge a book by its cover, because there are many people who can be U.S. citizens and don't even know it. And an example I'll give you, well, let me tell you first, you are a U.S. citizen if you are born within the United States, right, by the Constitution. So that's one way of you can be a U.S. citizen, but you can also be a U.S. citizen in three other ways. I'll give you an example of a citizenship clinic I just did in Lexington, where I had a 52-year-old lady come to the clinic. She was ready, she was excited, she said, I know my questions, I'm ready to apply. And we went through my normal consult, and I asked her, well, where were your parents born? And she said, my mom was born in California. I'm like, well, wait a second. So you are already a U.S. citizen. And given this lady went through a whole process to become a legal permanent resident, thought she entered illegally, thought she was undocumented for a while, and finally received her residency, to come 52 years later and know that she's a U.S. citizen. So sometimes even our very own clients don't know that they are U.S. citizens. So that was by acquisition. If you're born outside the United States to a U.S. citizen parent, given some other requirements, because there are changes in the acquisition part of the law, changes quite often. But for this 52-year-old lady, it did apply, and she is applying for her certificate of naturalization. Basically, she only had to retake her oath, and she was already a citizen. And then the third way that you can become a U.S. citizen is by naturalization. So this is the most common you'll hear. You take a test after 5 or 3 years, depending on how you received your residency. I'll go into more detail about naturalization a little later in the presentation. And then there's by derivation, you can become a citizen. So this is a really cool one too, because usually it involves a parent that is naturalizing, that is, they took the test and are ready to take the oath. And it's really cool because if there's a legal permanent resident child right by them at the oath ceremony, at the same time that that parent is taking the oath, that child is also becoming a U.S. citizen because they are in the legal and physical custody of their U.S. citizen parent. And then the other category, and then the other side of citizens and non-U.S. citizens. So under non-U.S. citizens, there's also lawful permanent residents. Those are people who have can stay in the United States for an indefinite period of time. These are the people that we say have a green card, and they renew it every 10 years. And can renew it 6 months before, actually, and that's not commonly known. And then there are also people who flee persecution. So these are asylees and refugees. Asylees apply for asylum within the United States. They have to prove that they have been persecuted for their race, religion, national origin, membership in a particular social group, or they fear they are being persecuted in their country, in their home country. So that's not in the United States. And then there's refugees. They apply for this based on the same thing, on fear of being persecuted for one of those protected statuses, but they apply from outside the United States and come in lawfully. Then there are people with temporary permission. So those are people with TPS, temporary protected status. That's given by the United States to certain countries, and those countries are given permission to, not those countries, the people from those countries who are already located in the United States are given permission to stay here for 1 to 2 years, depending on the contract or law that executive order that the country has done, and they can stay here for a certain amount of time, based on the country going through either a civil war or a natural disaster. Under TPS, then there are non-immigrants. So those are people that come in with visas, tourist visas, student visas are the most common, worker visas. And then finally, there are people who are undocumented, and that makes up 11.3 million people in the United States. So these people don't have any lawful status, they don't have a work permit, and don't have any way to become a legal permanent resident as of yet until they see an attorney. So one thing we like to do in every single one of our presentations is change one term that we commonly hear, and even our own clients use. And if you hear it, I would also encourage you to change that. So the term illegal, it's not only dehumanizing, but it's also incorrect, because people who entered the United States without inspection, that is, they didn't enter the foreign immigration official, they have not committed any crime. It's only a civil penalty. So it is incorrect and also dehumanizing. And another point is we don't use this term with other people, right? We don't use it with people who commit traffic offenses. We don't use it with people who have committed murder. So it's just not a proper term to use. The more friendly term would be undocumented. And I talked about the number, 11.3 million people being in the United States. So now I'd like to talk to you about the path to U.S. citizenship. So one thing we hear a lot of comments on is, why don't they just get in line, right? Well, there are only 4 lines to become a legal permanent resident, because the path to U.S. citizenship starts with you being undocumented at times. Not everyone comes undocumented. Then you become a legal permanent resident. Then you become a U.S. citizen. And then to even get to the legal permanent resident part, you need to fall under one of these 4 categories. And that is the diversity program, the employment-based immigration program, family-based immigration, or humanitarian relief. And I will talk about family-based and humanitarian in detail, but the top 2 we really don't deal with, but I will explain what they are. Diversity program is basically like a visa lottery. You apply from outside the United States. It can't be from 4 countries. So China, Philippines, Mexico, and India do not qualify for the visa lottery program because there is such a large immigrant population from those countries in the United States. So everybody else can apply. However, there is a catch. You have to apply online, and many of the people who would likely want to come to the United States are probably in third world countries and cannot afford internet, or they do not have access to internet. And that's an online application that you would submit. There's a certain amount of visas that are given every year. And just like the lottery, they're just taken out and you get a green card. And then the second program, or the second way to obtain legal permanent residency is employment-based immigration. So we don't often deal with this as a nonprofit because usually companies can afford their own private attorneys. But employment-based is usually, if you've heard of Google, Apple hiring engineers from abroad, this is usually through employment-based immigration. And usually you are from, or you practice a career that is highly skilled, and then you are petitioned to come to the United States. However, that company does have to prove that they cannot find someone with like skills in the United States to hire. Next, there's family-based immigration. So there's immediate relatives and preference categories. They're split into two, and I think I have a slide specifically on those, so I will save that for later. And then under them, under the next fourth path to U.S. citizenship is humanitarian relief. So I talked about refugees and asylees, and then there's relief for victims of crime as well under the humanitarian path. So there are people who apply under the Violence Against Women's Act. So those are spouses of U.S. citizens or parents or children of U.S. citizens who have been abused by the U.S. citizen. Then there's U visa. You can apply for a U visa if you have suffered a crime within the United States and you have collaborated with the police in the prosecution of that case. However, for the U visa, you do need certification by either the law enforcement, by the judge, or by the county attorney or the prosecutor. They need to certify that the crime did indeed happen. However, just certifying that the crime did indeed happen does not give them the grant of a U visa. So once you get the U visa cert, you still have to apply for the U visa, and then that's when USCIS decides whether to give you the U visa or not. Lastly, there's T visa for relief of victims of crime. So the T visa is for people who have been trafficked into the United States. This occurs very often, unfortunately, with undocumented immigrants, because necessarily sometimes they have to hire a coyote or a smuggler in order to enter the United States. From what we've heard in the news, they now charge $15,000 to enter the United States. To smuggle them into the United States. So, and these people are probably from third world countries, so they cannot afford $15,000. Otherwise, they probably wouldn't be looking for anywhere else to live. So they say, okay, I'll get you this amount, and I'll pay you when I get there, right? And so they come to the United States. They're not able to find work really fast, and they can't pay off the debt. Consequently, that smuggler then turns into a trafficker and forces them to work or do sexual acts in exchange to lower the debt. Then there's special immigrant juvenile status. I'll talk about this very little because Mindy will cover it in great detail. But it is for children who have entered the United States unaccompanied or with one of their parents and have been abandoned, abused, or neglected by one or both parents. Then there's DACA. So this has been common in the news. DACA was implemented by President Obama during his term through an executive order. It didn't pass through the legislature, so it's not law technically, and the Trump administration could take it away. In order to qualify for DACA, you have to have had entered the United States before you were 16 years old, be continuously present in the United States since 2007, and be enrolled in school, and have good moral character. So even one DUI can disqualify you from DACA and put you in removal proceedings. And sometimes not even that, as we're seeing some DACA children put into removal proceedings without a criminal record. And then lastly, there's temporary protected status. I did talk about that earlier. And non-immigrant visas, temporary worker visas. Those are other forms of relief. I do want to explain the difference between immigrant and non-immigrant. So immigrants are people who intend to stay here in the United States. Non-immigrants intend to stay here for a short amount of time and then return. So those are tourists, students who come from other countries and then return to their home country. So now getting into detail about one of those branches that I didn't get to talk about much was it's family-based immigration, so immediate relatives. You can receive a petition through one of your relatives. However, that's really limited. So remember, there's family-based immigration, there's immediate relatives, and there's preference categories. For you to qualify as an immediate relative, you have to be a spouse, child, or parent of a U.S. citizen. And those are even further limited. So children are only children if you're unmarried and you are under 21 years old. And then you're a parent only if you have a U.S. citizen son or daughter that is over 21 years old. So this is where that term anchor baby is also not appropriate, because the parent can't receive any benefit from the child until they are 21 years old. So unless that baby is born 21 years old, you don't get any benefits. Then there's preference category immigrants. So this is, we're done with immediate relatives. This is everybody who does not fit under the immediate relative category. There are 4 preferences. The first preferences are those that are unmarried sons and daughters over 21 years old of a U.S. citizen. The second preference, and this doesn't make much sense as for the preferences, but I will show you a chart that's coming, and that will make a little more sense. Second preference are spouses and children of a legal permanent resident. Then the second B are unmarried sons and daughters of a legal permanent resident who are over 21. Third preference are married sons and daughters of U.S. citizens. And fourth preference are brothers and sisters of a U.S. citizen. So I'm going to give you an example so you understand what this chart means. I just updated this, so this is March, as of March of 2017. So I'm going to talk to you about a client I just met in Scottsbluff. So, not a client, I'm sorry, a consult. And she told me, I really want to petition. She's a U.S. citizen from Mexico, and she wants to petition for her child, who is over 21 years old. And she was really excited because she was like, I finally have the money to do it. And so I unfortunately had to show her this chart. And that child, as I mentioned, is over 21 years old. He's not married, so he's an F1 category. And then we go to Mexico, and if you go down F1, you see that they are currently processing applications from May 15th, 1995. So when she heard that, she's like, so that's 20, 30 years from now. And I'm like, well, it's actually worse. If you see the next slide, it's 49 years. So mom is currently, 50 years old? Son is probably 20 years old. By the time he sees the application, he'll be 70 years old. This is why there's no line. This is why people say the immigration system is broken. And one question I often get is, why is it that way? Why do we have these long lines? Why don't they fix that? Well, as I mentioned in this immigration system, Department of Homeland Security gets a certain amount of funding, right? And guess where most of that funding goes? Yes. So most of that funding goes to protecting our border, and it doesn't go to USCIS, who processes the applications that are taking years and years to process. How do you fix that? Through Congress. Sorry, I'm taking you through many slides. And then an even worse one is a U.S. citizen brother or sister who wants to petition for someone in Mexico. Their brother or sister, wants to petition for their Mexican brother or sister. As you can see, that's 162 years. So they won't see that in their lifetime.
So they're processing applications for people that are basically dead at this point.
That's correct. So there is a line, but you die in that line. So the lines are already bad, right? There's more you have to meet. So there are grounds of inadmissibility. That means you cannot you cannot become a permanent resident. And these are some of those hurdles. I'm not going to bore you with all of them, but these are the main ones we see. The top one is health. So if you have a communicable disease, you're not admissible into the United States. You can't get a green card. If you are unvaccinated or you have a physical and mental disorder, you are not admissible to the United States.
What qualifies as a physical disorder?
Oh yeah. The question was, what qualifies as a physical and mental disorder in order to be inadmissible? You want to take that one?
It depends, and that's going to be our answer for a lot of specific questions. It depends. For example, a few years ago, alcoholism was considered a health condition that prevented admissibility. However, with work of advocate organizations, that's no longer being used as a ground of inadmissibility, but it's basically communicable. Diseases are our priority, but if there's any suspicion about this particular applicant and there's any type of physical or health disorder, this could be used as a ground.
So lupus or any of the autoimmune diseases, for instance.
It could be used as a ground of inadmissibility, yes.
You have to go through a medical exam, so this won't necessarily come out. And
Now, these are administrative executive statements of eligibility.
so the question,
Statutory.
These are statutory. They're found in the INA, the Immigration and Nationality Act. So these are statutory.
Executive interpretation for executive orders to change.
Right. So when Rosangela talked about DACA, Deferred Action for Childhood Arrivals, or TPS, those are forms of relief created by executive order. And later in her presentation, she'll talk about the recent executive orders by President Trump. But the grounds of inadmissibility and removability, and then generally the forms of relief are statutory and can't be changed just by the executive.
and then the next category that you can be inadmissible are certain crimes. So, so one thing I often have to explain to my clients is, criminal convictions and immigration inadmissibility grounds don't exactly merge. So you can have a misdemeanor under criminal law that can make you inadmissible under immigration law, even though it's just a misdemeanor. So it's something to teach our clients and to really watch their criminal record and try to prevent that from ever happening. Okay, and then so also under certain crimes, so immigration law, so criminal law, we all know convictions, but under immigration law, there are crimes involving moral turpitude. That's how they're termed. So in order for you to be inadmissible to the United States, there are also aggravated felonies, and those are further defined within the INA. And if you fall under one of those categories, even if it's a misdemeanor, you are inadmissible to the United States if you don't qualify for a waiver. And then if you are likely to become a public charge, so that is if you're likely to be asking for public benefits, you are not admissible to the United States. If you have certain immigration violations, so if you are present in the United States without inspection, that is, you are here without permission, you are also inadmissible to the United States. However, there are certain waivers for that, but they are really limited, and I'll talk about that a little bit in a little bit. So you are also inadmissible if you have ever claimed to be a U.S. citizen, and this is something we see very common. Because if you come undocumented to the United States, you necessarily need to work, right? And on that I-9 form, it's very easy to just check you're a U.S. citizen, and they unknowingly mark that, and consequently can never become a legal permanent resident because they have marked the I-9 that way. Lastly, there's unlawful presence. So if you entered without inspection and you have been present in the United States, or you entered with a visa and overstayed your visa, for more than a year, you trigger a 10-year bar. And when I talk about 10-year bars, it's easier to understand when I mention it in an example. So I always use a single mom who has a 21-year-old daughter who is ready to petition for her. Everything's good. Mom entered without inspection, so she's been here for 21 years, right? And the daughter wants to petition for her. However, she's a single mom, so there's no spouse, and there are no parents. They are both in home country and never been citizens. So we enter the United States. She entered the United States 21 years ago. Daughter is ready to petition for mom. So sometimes, because there are a lack of immigration attorneys, daughters just petition for their parents thinking, oh, that's all I needed. I'm 21, I can petition for my mom now. But what they don't know is that they have already accumulated more than 1 year of unlawful presence. They have triggered a 10-year bar. At the point that mom goes to her consular processing interview, because they will process the application, and they will tell her, the National Visa Center will tell her, your interview is scheduled for this date. As soon as she leaves the country, she triggers that 10-year bar and cannot come back to the United States. For 10 years. And that's only for a year of being here. However, there are waivers for that. But this single mom does not have a U.S. citizen or legal permanent resident spouse. She also doesn't have a U.S. citizen or legal permanent resident parent. So there is no waiver for that, and she is now stuck in home country. There is also a permanent bar. So if you, like I mentioned, if you falsely claim to be a U.S. citizen, you trigger the permanent bar. You also trigger the permanent bar if you left the country and come back in without inspection. That is, you don't pass before an immigration official. So if you do that twice, you have triggered the permanent bar as well. Then there are grounds of deportability. So say you are already admissible, you are already a legal permanent resident, you can still be deported. And these are a few grounds of deportability. I won't tell you all of them, but these are the main ones that we see. So the top one, obviously certain crimes, aggravated felonies and crimes involving moral turpitude under the INA. And then failure to just timely file a change of address form, that can trigger you to be deported. Falsification of documents. So if you lied on some government application. If you falsely claim to be a U.S. citizen for security grounds, you can be deported. If you're a public charge, you're likely to apply for public benefits, or for unlawfully voting, as we just saw in that case in Arizona, for someone who unlawfully voted is now deported to Mexico. So now to maybe brighten up your day a bit, let's talk about U.S. citizenship. It's a nice term. Yeah?
On the news within the last month, when they are emphasizing arresting, deporting undocumented, they're saying any crime, speeding, running stop sign, any crime at all justified them being arrested, detained, and deported.
That is correct. So that's through an executive order. So like Mindy said, this is by statute. These are the grounds of inadmissibility, but the executive order can change the priorities of removal. So the priorities of people that should be removed from the United States. And I will talk about specifically those changes that have occurred. So U.S. citizenship, you must have continuously resided in the United States for 5 years as a legal permanent resident, or 3 years if you are married to a U.S. citizen, and that's how you obtain your resident status. You must be at least 18 years old, a person of good moral character, and you must have ability to read, write, and understand English. However, there are exceptions for people who have disabilities or have been a legal permanent resident for a long time and are now elderly. There's also, you must understand the fundamental history and principles of the U.S. government. So there are 100 questions. You can look them up online. They're on uscis.gov. And you have to memorize all 100. And out of the randomly, 10 of those will be selected. And during your interview, they will ask you those questions. And you must pass. You must also write a statement in English. And you must also be able to read it. So I'm going to go back far. So signed executive orders. I do want to cover what has happened in the last month, actually. So these are the 3 executive orders that have been signed. I will go into them. I will talk about them in detail. So starting off with enhancing public safety in the interior of the United States. So like you mentioned, the enforcement priorities have changed, and that is what we are seeing in the news. So let me give you a little bit of background for you to understand how drastic the changes are now. Under the Obama administration, there were 3 categories of people who were priority to be removed. The top one were people who were a public threat, terrorists, and the second part were misdemeanors, or people who committed, people who have misdemeanors such as DUIs or DV, domestic violence type assaults. And then lastly, there are people who entered from 2014 up to now. That was under the Obama administration. So those people were, primarily those people were to be removed, right? And they did comply. 98% of the people that were deported during the Obama administration met those guidelines. So now, the new enforcement priorities involve people who have committed a criminal offense. So, and they don't define criminal offense because Secretary John Kelly just came out with some memos to the Department of Homeland Security to specify how exactly the Department of Homeland Security should enforce these priorities, that term wasn't defined. So people who have been convicted with any criminal offense, and that's convicted. So that's one. The other one that worries us a lot are people who just have a chargeable criminal offense. So that means they haven't even been convicted, and you can still be removed from the United States. And that can include a traffic offense, that can, and you weren't caught, or that can include you jaywalking, and you can be removed from the United States. Those are the two most drastic changes in the priorities, aside from the ones that were before. So basically, the new set of categories, and if you see them all, it's a long list. Of the 11.3 million immigrants, undocumented immigrants that I said there are in the United States, 8 million of those meet those priorities. And then under this other executive order, there are also assessment and collections of fines and penalties on immigrants unlawfully present and those who facilitate their presence. So that fines and penalties haven't really been enforced previously. And when I'm talking about fines and penalties on immigrants, those mean those that have smuggled people into the United States, and those also that have petitioned for their family members, and now those family members that they petitioned for have applied for public benefits. Technically, they entered into an agreement where in that case, that person that they petitioned for should not be applying for public benefits, and if they did, they would then charge the person that applied, the person that petitioned for them. So that's something that is being looked into also as the result of this executive order. So these are executive orders. They're still at the top. There are still regulations that need to come down and further memos to really specify what they are talking, or maybe not. Sometimes they may not come out with memos specifying those. Next, there are states and localities are deputized to enforce federal immigration laws. So you probably have heard of G687, right? 287. 287G agreements, and those are agreements where the local police and the state police agree with or cooperate with ICE agents and act as ICE agents themselves in order to enforce immigration laws. So they are able to detain people. That is up to each local police and state police whether they want to cooperate with federal ICE agents. So that's a conversation that needs to be had here locally. And then there are Secure Communities program, which is now revived through this executive order. This really just enforces that cooperation between federal and local police to detain people based on them being undocumented and then forwarding to ICE. Lastly, this executive order also punishes sanctuary jurisdictions. So sanctuary jurisdictions are counties, states, or cities that choose not to cooperate with federal ICE agents in detaining their people. The two common ones that we've heard are New York City and California. And what this executive order does is that it will withhold federal funding from these states or counties or cities who choose to be sanctuary jurisdictions. The next executive order is border security and immigration enforcement improvements. So the first one is to construct the border wall. From what I was reading yesterday, it will cost about $21 billion just to do the border and extra sections where it's not at. There will also be fast-track hearings for detained individuals, meaning that individuals will, as soon as they come into the United States, they should have a hearing, and at times they may have to fight their hearing from outside the United States. It will also dramatically reduce possibility of release for certain asylum seekers at the border found to have credible fear of persecution. And then lastly, it will dramatically expand use of expedited removal proceedings. So this is really something that is going to change our system here, and meaning that now, well, let me give you some background. So at the border, within 100 miles of the border, you could be expeditedly removed, which means you could be removed within 24 hours without seeing a judge. That is if you can't prove that you entered without inspection or that you have legal status. This executive order takes that away, so now in the entire country, you can be expeditedly removed if you cannot prove that you entered without inspection and you cannot prove you've been continuously present in the United States for the last 2 years. And this is where a lot of safety planning comes in, and a lot of education to our community members to teach them that they do need to have this information safe and ready to go. Also have powers of attorney, temporary delegation of parental powers ready in case this were to occur. The next executive order is the one that we probably heard most on the media, is protecting the nation from terrorist entry into the United States by foreign nationals. So this stopped refugee admissions for at least 120 days. It reduced the number of refugees admitted in 2017 from 110,000 to 50,000. It prioritizes refugee claims based on religious persecution, where a refugee's religion is the minority religion in that country. Syrian refugees are barred indefinitely. It bans immigrant and non-immigrant entries, so meaning people who have their petitions already approved by their family member, or people who have their visas. Those people cannot come in for at least 90 days for nationals of Iraq, Iran, Libya, Somalia, Sudan, Syria, and Yemen. Then there are federal court and, what I wanted to explain is the asterisk. So the asterisk on this slide shows what has been stated. So these are not valid. These clauses are not valid right now because of the process that went through the state court and the Ninth Circuit. So the federal court in Washington State, along with Minnesota, went to the Washington District Court and issued and requested a temporary restraining order that was granted by that state court. This was then appealed by the government or the Trump administration to the Ninth Circuit Court to stay that TRO, the temporary restraining order. They decided to keep the Washington State Court's decision in place until the appeal is to be taken up to the Supreme Court, if that is what the Trump administration seeks. From what I've seen, he does not seek to appeal it. He actually just wants to amend the executive order so he does not end up in court again. So he did say he was going to issue that last week. It hasn't come out as of yet. And then now I can take general questions if you have any. That's the end of my presentation, and I will hand off to Mindy to finish up. No questions?
There's going to be some more detailed information about status and what, like Nikki, how that affects children that are in the system that are here with undocumented parents. That can be addressed in the next session.
Yes, that is what's going to be addressed by Mindy. I just wanted to give you some basics so now you understand some of the terms that she will be talking about. Okay, thank you.
All right, like Rosangela said, my name is Mindy. I also work for Justice for Our Neighbors, and I have a particular interest in special immigrant juvenile status. A couple years ago, Justice for Our Neighbors was really the only organization with attorneys working on these type of cases in Nebraska, but now because of outreach, we have a lot of private attorneys that are also taking special immigrant juvenile cases throughout the state. The reason that it's particularly applicable to guardian ad litems is if you have an undocumented kiddo that you're JAL for, special immigrant juvenile status is likely an immigration form of relief that kiddo is going to be eligible for. So it's something where you can actually ask your judge to appoint an immigration attorney to represent that kiddo as far as, they're processing the application for special immigrant juvenile status. Justice for Our Neighbors attorneys get appointed throughout the state as immigration attorneys for kids in juvenile court, or we can work with you to learn how to do it as well. It's not that hard. So this is what the last half of the presentation is going to be, but after I'm done, if you have questions that relate to other things, that's cool too. And feel free to interject if you have questions as we go. The cool thing about special immigrant juvenile status is it's actually mentioned in a couple of our state statutes. There is a requirement, and I don't have it on the slide, but if there's an undocumented kiddo in juvenile proceedings, DHHS is actually required to work with the home country of the child, their consulate, to try to see if special immigrant juvenile status is an option for the kid. We're going to talk about what it is, what SIJS is. We're going to talk about who's eligible. We're going to talk about how we get there. We're going to talk about how the federal immigration law relates with the Nebraska state laws. And we're going to, again, talk about how GALs can help with the process. The form of immigration relief called Special Immigrant Juvenile Status has actually been around for a really long time. It was implemented under the Bush administration. It was most recently amended in 2008. But like I mentioned previously, it's kind of an unheard of form of relief, and it hasn't really gotten a lot of attention until the influx of unaccompanied minors coming to the United States started to surge a few years ago. SIJS is focused on children. When I say children, that means that you have to apply for SIJS before you turn 21. However, there's a requirement that you get a state court order before the child reaches the age of majority, which in Nebraska is 19. So we really need to identify these kiddos before they're aging out of juvenile court jurisdiction. It protects children that have been abused, abandoned, or neglected by one or more of their parents in their home country. Okay, so when we're doing consultations with these children that have arrived in the United States, we'll ask them, have you been abused or abandoned or neglected by your mom or dad? They're most of the time going to say no, because that's all they know, right? You get into the details and you find out that the kid oftentimes went without clean water, oftentimes went without enough to eat, almost always went without an education past the first few years, and almost always works much harder than any of us in this room works. And so based upon those facts, it translates into more of a neglectful situation according to the laws that we're used to. And so in essence, most of the children that have fled to the United States unaccompanied would qualify as being abused, abandoned, neglected by one or more of their parents. If you're able to obtain SIJS status, it is a form of relief that could lead to citizenship. So Rosangela talked about DACA, Deferred Action for Childhood Arrivals. That's just a temporary form of relief. It's never going to lead to a green card. It's never going to lead to citizenship, right? She also talked about temporary protected status. That's not going to lead to a green card or citizenship. But SIJS will. After you obtain the SIJS status, there is a process to apply for your green card, and then like Rosangela said, after 5 years, you could theoretically apply for your citizenship. So this is a path to citizenship for these children. One interesting fact about SIJS status is if a child obtains their residency or their green card through SIJ, they can never petition for their mom or their dad. Okay? So what that means is the parents can never benefit from SIJS for their child, which makes sense, right? Except for the situations where the child's been abused, abandoned, and neglected by one parent, and there's a very loving parent who's never abandoned, abused, or neglected the child. That parent can never benefit from the child's SIJ status. Does that make sense? This is where the form of relief come from. It is reflected in the INA, so it's a law. So it's not something that the new administration can just take away without an act of Congress. It's not something that was created by an executive order. But there is some language that's not easily definable. So if we look on the next slide, the SIJS application has to be started after we receive a state court order. And the state court order has to come from a juvenile court, right? But as you can see, that definition of juvenile court is actually going to apply to more courts than just the juvenile court. It's a court that's located in the United States that has jurisdiction over the child and can make decisions about the care and custody of the child. So the most obvious example is when a kid is in 3A or 3B proceedings, has been abused, abandoned, neglected, and is in juvenile court because of that. That's the most obvious example of how we can get that juvenile court definition. But as you'll see later in the slides, there's other ways that we can qualify a court as a juvenile court. If we're doing a divorce with custody, that court has a jurisdiction over the best interest of that child. They make the custody determination based upon the best interest of the child. So that district court that's in the divorce proceedings also qualifies as a juvenile court. Another common example is the county court that is deciding guardianship orders is also qualified as a juvenile court because they're placing the child into the custody of the guardian. Theoretically, they're making the determination about whether or not that child needs a guardian based upon the best interests of the child. So those are probably the most common definitions of juvenile court. I think the next slide kind of lists them all out. In the first version of the law that created the form of relief, SIJS, there was a requirement that the child had to be in long-term foster care. So really that narrowed down the kids that were eligible for this form of relief. Since then, that requirement has been removed. And so just a child that's been placed in the custody of another individual or a court is going to be eligible for SIJS. There's no requirement that the child ever be placed into the custody of the Department of Health and Human Services or within a foster home. Like I mentioned before, a child's an unmarried person under 21. We get a lot of clients, a lot of unaccompanied children from the Central Triangle and Northern Triangle in Central America, which is Guatemala, El Salvador, and Honduras. And culturally, we've run into children that are married. They're forced into arranged marriages. They've been abused and things of that nature. And so when we've had the 15, 16, 17-year-old child that's married, we think, oh no, they're not going to qualify for SIJ form of relief, even though they've clearly been abused, abandoned, neglected in their home country by their parents. Once we're able to annul that marriage or even end the marriage in a divorce, they are then again qualified for SIJ. The child also has to be physically present in the United States. So this is not something that a child can preemptively apply for while they're in their home country. They have to actually be in the United States. And then probably the most important piece is they have to have that predicate state court order and from a Nebraska judge. We also work with kiddos in Iowa, so there's a little bit of difference there. But in Nebraska, we have to get that predicate order before the kiddo turns 19. In Iowa, we have to do it before the kid turns 18. But the court order has to specifically find that the child had been abused, abandoned, or neglected by one or more of their parents. The court order also has to specifically find that it's not in the child's best interest to return to the home country or the country where the child last resided. And the court order also has to find that reunification with one or more of their parents is not viable. In Nebraska, for a long time, we were only doing SIJ cases where both parents had abused, abandoned, neglected the child. But SIJS is possible for a one-parent situation. So if you have a child with mom or dad and they've been abused, abandoned, neglected by the other parent, SIJ is something that they can pursue. This is the slide I was talking about. It lists the different types of court cases that you can use for the predicate order, okay? So we already talked about guardianships, conservatorships, custody and paternity. So that's for the one-parent SIJ situation. That's where the kid's residing with one parent. However, they had previously been abused, abandoned, neglected by the other parent. Obviously, the divorce or legal separation with the custody component. We've also gotten the predicate SIJ orders through probate cases, adoption cases. You know, in the domestic violence protection order, there's that ability to get a very small custody order in the PO. You can also try to get the SIJ predicate findings within the protection order itself, and that would be applicable. And then obviously in traditional juvenile court cases that have the abuse, abandonment, neglect component, also the 3B cases will work too. So even if the child's involved in proceedings that didn't initiate because of the abuse, abandonment, neglect, that judge can still make the SIJ predicate findings for their immigration case. Does that make sense? So for example, I was just appointed to 2 kiddos in Colfax County who had MIP charges, right? And when I did the consult with them, they were very adamant that they were not abused, abandoned, neglected by their parents. That's not why they're in juvenile court. They're in juvenile court because they went to a beer party, right? After further consultation, I find out that these kiddos both had severe injuries from when they were working in the fields. They were injured with machetes. One of them's father had abandoned right after he was born. There was just a lot of abandonment, abuse, neglect type situations that allowed me to ask that court in the 3B proceedings for an order, and I just called it an order, because if you ask for a special immigrant juvenile status order, the judge might be more reluctant to enter that. But if you just ask the judge for an order with the finding that the child has experienced certain neglectful situations in their home country, and that reunification with one or more parents not viable, that's going to be sufficient to apply for SIJS. Does that make sense? I know it's confusing because it's not actually an abuse and neglect case, but as long as you can get that judge who has jurisdiction over the child to make the appropriate findings, you can move it to proceed.
What specific claim? Does it have to be something in a court order that says that they're determined to be qualified as an SIJS?
No, that's a great question. So the question is, how specific does the state court order finding need to be? Does it need to specifically say this child is qualified for special immigrant juvenile status? And the answer is no. And in fact, you do not want to ask your state court judge to try to interpret federal law, right? So no, you don't want to title your order special immigrant juvenile status findings, and you don't want to ask the court to find that a child is eligible for this form of relief. You simply want to present evidence to the judge, and oftentimes we do it in the form of an unsworn statement, and we offer it as exhibit, so it's not publicly available, especially if we're doing like a divorce custody type action, or we'll offer a testimony based upon the abuse and neglect that the child's endured. Once the judge has admitted the evidence based upon the abuse, abandonment, neglect, then you'll ask the judge to make a finding of fact that yes, indeed, the child's been abused, abandoned, or neglected. And you don't want to say abused, abandoned, neglected unless the child's experienced abuse, abandonment, neglect. If the child's only been abused, you'll say this child's been abused. And you'll say a sentence about what the abuse is. If the child's been neglected, this child's been neglected. They haven't been able to go to school, they haven't had proper food, clothing, clean water, things of that nature. So you just write the facts of what the child's actually endured. Then you ask the court to make a finding of fact that it's not in the child's best interest to return to their home country, which I've never run into a situation where it's not in the child's best interest to remain in the United States, okay? Go ahead.
What is the foundation or basis for that motion as far as the evidence statement from the child?
That's going to be pretty much decided by local practice, all right? So each judge is going to require certain things in order to feel comfortable making certain findings of fact. In most of our cases, we are able to submit an unsworn statement by the child just kind of outlining what they've endured. We also submit an affidavit by the caretaker, either the guardian or the parent that's been awarded custody. A lot of times the judge will also want testimony as well. So we elicit testimony from the caretaker or the child based upon the abuse, abandonment, neglect. Some judges, I'm not going to lie, will require more substantial evidence regarding the country conditions of the home country. We encountered that a lot in maybe 3-4 years ago, where we would actually have to call experts to testify about the country conditions of Guatemala, per se. As I'm sure you guys know, the protections regarding children in the Northern Triangle countries are just not the same as they are in the United States. There's incredible gang violence, and the country conditions are that, so children are normally not safe. Then when you throw in the fact that parents are not able or not willing to protect their child, it's very easy to offer this type of evidence to make the judge feel comfortable making these findings of fact, but each judge wants it done in their own particular way. So we have our cards up front, and so if you have a particular question about a particular judge, we would certainly be willing to offer any advice if we have experience in front of that particular jurisdiction. What we do before we go into a new jurisdiction is we do a little background about the local practice and the judge to try to narrow our evidence so it fits what we feel the judge will feel most comfortable with admitting. So then the third piece is making the finding of fact that reunification with the abusive or neglectful parent is not viable. Typically, after you've made the finding of fact about what the child's endured, that finding that reunification is not viable is not that difficult. So, like I said, really the first part of a SIJ case is doing a consultation with that child. So at the end of the presentation and on the back of Rose and Angela and I's cards is the number for the Nebraska Immigration Legal Assistance Hotline. So if you're working with a kid in juvenile court that is undocumented, the first step is always going to be getting them an immigration legal consultation. That screening will try to pair that child up with a nonprofit, but if there's not a nonprofit that is able to take the case, then that child will get referred to private attorneys that are best able to take the case in the area. For example, Shantae is on the private attorney list. So if there's a kid in this area that has an immigration legal problem, Neela will send the family or the caseworker, whoever makes the application, a private attorney list of immigration attorneys that are able to handle SIJS cases. So that's the first step, is the consultation with an immigration attorney or a BIA representative. The second step is getting that state court predicate order, like we talked about, the juvenile court order, the guardianship order, the custody divorce order with these particular findings. Another thing that I should mention is if that y'all need help with the predicate orders, we will draft them for you and send them back to you. It's something that we do every day, and so we know what the predicate orders need to look like in order for the kiddo to be granted the SIJS status eventually. After the state court order has been entered, and literally you could apply for SIJS the day that the juvenile judge signs the order. There's no waiting period. But after the state court order has been signed, then the next step is your affirmative application to USCIS. The application for special immigrant juvenile status is called the Form I-360. And it's a lengthy application, but it's pretty straightforward, and it just asks for basic information. You have to attach the state predicate order, and you have to also attach some identification documents for the child, and then you submit it, and then you wait. After you submit the Form I-360, you'll get a receipt notice within 2 to 3 weeks usually. You'll get the receipt notice. And one thing that I'm interested in learning from y'all, if you know, is when a child is eligible for the Bridge to Independence program. I've had DHHS workers require a green card to be eligible for the Bridges program, but lately I've had caseworkers tell me that if I can simply prove the child is applying for SIJS, that they would be eligible at that point. So that's what's good to know, that right after you get that state court order, you can submit your Form I-360. Once you get your receipt notice in 2 to 3 weeks usually, perhaps there's a chance that that child may be eligible to enter the Bridges program at that time. The approval for the I-360 really depends. I think it's about 4 to 6 months right now, okay? So that's why it's really important to get some clarification about whether or not a child's eligible for Bridges based upon their application pending, their approval, or when they actually become a legal permanent resident. Like I said, it should get approved within 4 to 6 months, and then your next step is going from an SIJS kiddo to a legal permanent resident. So once you get your Form I-360 approval, you can immediately apply to adjust your status from a special immigrant juvenile to a lawful permanent resident. And the form you use is a I-485. The adjustment application, that's where we get into some of the more in-depth screening mechanisms for this child. There's a hefty fee. It's over $1,000 to apply for the I-485. However, most kiddos that are applying for adjustment based upon SIJ can waive their fee. when you apply for I-45 or adjustment status, you have to prove that all of those grounds of inadmissibility are not applicable to this child. So the child's going to have to undergo a medical exam, which is going to run probably about $500. The child's going to be tested for many diseases. The child's going to be made sure that their vaccines are all up to date. The child is going to be inspected from head to toe. Particularly what I've noticed is that the doctors are being trained to look for tattoos that could be gang affiliated. If there's any risk of gang affiliation, then the likelihood of this child becoming a legal permanent resident is very slim. If there's been exposure to TB and the child tests positive, then they have to go through the treatment before we can even start the application process. If the child's already been treated for TB but still pops positive, we have to get chest x-rays to show that TB is not currently active. And so this slide just kind of goes more into the screening process that these kids go to. I don't know if you guys have gotten this impression, but depending on which news channel you're watching, we're given the information that if a child enters the United States alone, that the red carpet's kind of rolled out and they're going to get their green card. And what we've learned is that's not the case. The detention center that they're initially placed in they're very harsh conditions. All of our clients refer to the detention centers as the cooler. They're very cold and they're not offered much in way of clothing or blankets. There's not enough food. They're isolated. If they have traveled with anybody, like siblings, they're isolated, and it's a very, very harsh conditions. Once they're released, go ahead.
With regards to that form I-485, so are all these medical procedures and screenings, is that after that application, or do you want to have that in order before?
Yeah, so that's a good question. So we talked about the costs of the I-485 and the cost of the medical exam, and the question is, do we need to have that done before or after the application is submitted? And the answer is before. So when you submit the I-360, really the hardest thing and the only thing you need to get is an identity document for the child and the state predicate state court order. But after that's approved and you want to apply for adjustment of status with the I-485, you're going to have to either one, get a fee waiver for that child, or two, come up with the fee. And the fees just increased, is it $1,275? It's very expensive, right? The fee is really expensive. So we either need to come up with that fee or we need to have a good reason why that fee is going to be waived. If the kid has been in the custody of the Department of Health and Human Services, I've had all of my fee waivers waived, or all of my fees waived for those kiddos. However, the medical exam, that's a different story. There's this law in Nebraska that says the state of Nebraska cannot do anything to benefit an undocumented person, right? So that may be a hindrance to a caseworker helping the child obtain this medical exam for purpose of applying for adjustment of status. Most of the time it's not been an issue, and either the foster care specialist or the caseworker will facilitate the child getting the medical exam. But the medical exam has to be done in order for the child to adjust to a lawful permanent resident. With one caveat, you can submit the application without the medical exam, knowing full well that you're going to get a request for evidence or an RFE, right? When you get an RFE, you only have a short period of time to respond. So if you get an RFE for not having your medical exam up front, that means that you're going to be able to have to get that child into the doctor, come up with the fees for the exam within this, it's usually 60 to 90-day period. So you need the medical exam for approval. If you want to risk it and submit the application and wait for the RFE to get the medical exam, you can do it that way as well.
That's my next question. So is there any kind of benefit or advantage of filing that, knowing that you're going to have to do the medical exam afterwards as far as procedurally for certain cases?
That's a really good question. So right now, there are no visas available for SIJS kids from the Northern Triangle. Okay, so if you have a kiddo that's from Guatemala, Honduras, or El Salvador, there's no visas available for special immigrant juvenile status. And Mexico was cut off, and then it was open for about 3 or 4 months, and now it's cut off again. So what that means is the SIJS visas are borrowed from a fourth preference category of employment-based visas, okay? So SIJ kiddos are only getting some leftovers of not used employment-based visas. Because there's been so many children from the Northern Triangle in Mexico using SIJ visas, right now there's no more available. We anticipate they're going to be available again in the next few months, but right now they're not available. So if you're going to be and we're not submitting any I-45s right now, because there's no point. We're waiting until the visas are available again, and then we'll start submitting the I-45s again. However, if there's some reason that you need to submit your I-45 when there's no visa available, there would be a strategic decision that needs to be made whether or not you do the medical exam before or after you get the RFE. The medical exams are typically only good for 6 months, so there are situations where you'll submit your initial application with a medical exam. If your interview is not held for a long time or adjudication's not for more than 6 months, then you'd have to get another medical exam. So that's a really good question. The child also has to go in for photographs, fingerprints, biometrics. What that is going to screen for is if the kiddo has been convicted or charged with any crimes. The child is also subjected to an interview process. The interviews used to be relatively short and sweet. However, since a new administration has come into play, the interviews have significantly increased in both length and severity. So the adjudicators are now being, I think, asked to screen for certain things that they used to not screen for. So the kids are being asked, when's the last time your parents sent you money, if they ever sent you money? Did they help you pay to get to the United States? Have you sent your parents money? Who did you cross into the United States with? Like Rosangela said, being in the United States without permission is not a crime. But if you crossed into the United States with someone else, then that it could be considered smuggling, right? Even just if you're co-traveling, if Rosangela and I are coming into the United States without inspection and I offer her a drink of my water, then I could be prosecuted for smuggling. So what we've seen is the immigration adjudicating officer for the SIJ kids, when they're applying to adjust to lawful permanent resident, they're screening for smuggling issues. They're screening for these. So that's why it's so important that immigration attorney goes with the child during the interview process to make sure that there's no admissions that were made that would prevent the child from adjusting status from SIJS to LPR. We kind of talked about this. Obviously, the predicate state court order is required for the kiddo to even apply for SIJS. But one thing that we just want to hit home is we're not asking the state court judge to make a decision on whether or not the child qualifies for SIJS, right? So that kid's going to get screened through by an immigration official 2 times. First, when their I-360 is being adjudicated, and second, when their I-485 is being adjudicated. That's enough. We don't need to make the juvenile judge or the county court judge try to decide whether or not the child meets the qualifications for SIJ. I don't know if any of y'all are familiar with the case of Eric M. It was a case that came out of Lancaster County Juvenile Court, and Judge Porter found that she could not adjudicate an SIJS case where she couldn't determine if reunification was not viable with mother. She could determine that it was not viable with father, but she couldn't determine if it was not viable with mother. Well, the problem with that case is Judge Bauer was asked to determine whether or not this child qualified for SIJS. And in fact, the immigration attorney presented, I said Judge Bauer, I meant Judge Porter, the immigration attorney, I think it was a student at the clinic, but they presented the judge with an order that said special immigrant juvenile findings of fact. And within the order it said this child does qualify for SIJS, right? So that in itself forced Judge Porter to try to figure out what the federal law interpretation of SIJS meant. And she interpreted it to mean that she had to find that both parents could not be reunified with the child, when in fact we saw in the previous slide that the regulation or the statute only requires one parent to be found to not be viable for reunification. So that's why it's very important, don't ask your judge to make any determinations on what does or does not qualify as special immigrant juvenile status. And again, one thing that you'll have to educate the judges about is that once that state court order is entered, it does not mean that that child is going to get an immigration benefit, right? It's very similar to what Rosangela talked about with the U visa. A U visa is a form of immigration relief that could lead to a green card, right? It starts with a law enforcement officer certifying that a certain crime committed. Well, what we've seen in Nebraska is that law enforcement agencies do not want to sign U visa certifications because they don't know whether or not this person would qualify for an immigration benefit. They don't feel comfortable saying that this victim qualifies for this form of relief when there's all these other victims out there. And so what we've had to do, and what each immigration attorney has to do in the U visa case, is educate that law enforcement agency that by signing a U visa certification, you are not making any immigration decisions whatsoever, and this person is not going to get an immigration form of relief because you signed this certification. This is very similar with the SIJS process. So I've had judges tell me, I am not comfortable entering an order that's going to give this child an immigration benefit. And so what your response is, judge, you're simply making findings of fact about the abuse, abandonment, neglect this child's endured. You're not making a finding of fact. You're not making any determination on whether or not this child qualifies or is going to be granted SIJS or adjustment of status. So once you get the education piece out of the way, it seems to it makes the judge more comfortable that they're really just doing the things that they're used to doing already. We're asking judges who make best interests of child determinations every day and make findings of fact regarding the best interests of the child. That's all we're asking the judge to do. We're not asking the judge to make any type of immigration determinations. Does that make sense? So in your slides, you'll see there's case law here. I'm not going to read it, but basically I wanted to point out that the appellate court here in Nebraska has recognized SIJ as a form of relief and has recognized that state court's role in the SIJ as procedure. So not only has SIJ been recognized in statute, but it's been recognized by the Court of Appeals as well. And then courts across the country have also recognized that this is that federal law directs state courts to make findings of fact regarding SIJ as kiddos. Not determinations, findings of fact. On this slide, the second case that I outlined there, that's the Eric M. case that I was just talking about. And unfortunately, in that case, Judge Porter didn't feel comfortable signing the proposed order that she was presented. But that case does offer us some good precedent that she actually outlines that courts can enter findings of fact regarding SIJ, and that federal court directs the judges to do so. So it does provide, even though it was ultimately unsuccessful, it's good in the fact that it recognizes that Nebraska courts should be doing this when appropriate. So I'm assuming that most of you have worked with children that are undocumented. I think that in the juvenile court setting, the biggest hindrance of working with a juvenile that's undocumented is your permanency options, right? So if you have a child that's undocumented, is independent living an option? It probably is not, right? If the child has no access to public benefits, if the child has no access to work authorization and things of that nature. So when we're exploring forms of immigration relief, just in the juvenile court setting, we're opening up another form of permanency, which in my experience has really been the only form of permanency for the children that I've been appointed to help in juvenile court. But just on a bigger issue, when we're talking about the experience of an undocumented person, Rosangela briefly mentioned unlawful presence, right? So if you're in the United States as an undocumented person, once you leave the United States, you trigger either a 3 or a 10-year bar. If you come back again and you leave, you're triggering a permanent bar. So we have kiddos that we're working with that are here, and they have a grandmother, perhaps, who's cared for them their entire life before they came to the United States, who can't care for them anymore, but she's dying, and the child, there's no possible way that that child can go home to visit or say goodbye to their grandmother because of the 310 or permanent bars. We're talking about no ability to apply for Pell Grants for college. There's no social security number, so going on field trips at their school is often not an option. We're talking about keeping their immigration status a secret from not only their teachers and the administration, but many of their friends as well. We're talking about if they are forward with their undocumented status, then we're talking about them facing discrimination by not only adults, but by their peers as well. So when you offer that first immigration consultation and somebody's listening to what this child's endured and also offering paths to move forward on the path to citizenship or on the path to some type of immigration status, you can just see the child change. You can see opportunities starting to take root. You can see that immediately they have less fear. They're less vulnerable to being exploited. Rosangela talked about the U visa and the VAWA and the T visa forms of relief. The reason that there's forms of relief for abused, abandoned, neglected kids in SIJ and forms of relief for victims of crime is because if you're an undocumented person in the United States, you're much more susceptible to being victimized, right? Once you're victimized, then you're also less likely to report that victimization for fear of deportation or removal. So it kind of creates this imbalance of power, and it perpetuates a cycle of violence. The reason that these forms of relief are available is to stop that cycle of violence and make some avenue of relief so victims feel more comfortable reporting their victimization. So the JFUN client quote that I put on this slide, and we get really amazing quotes all the time, but this child said, well, in truth, I feel very different, much, much more confident now in myself that I can achieve many goals that before I didn't know or hadn't thought of. So I think that if you just take that quote in mind, when you as the GAL may not be necessarily assigned to care about the child's immigration status, but the fact that you do and the fact that you're willing to support an immigration consultation opens up so many different possibilities for this child, not just permanency, but many more social, emotional, even physical benefits for these children. Now we talked about the NELA hotline before. The Nebraska Immigration Legal Assistance Hotline is a collaboration between most of the non-profit immigration legal service providers in Nebraska. So Justice for Our Neighbors is a collaborator, but also Catholic Charities, Lutheran Family Services, Center for Legal Immigration Assistance, or CLIA, and the Women's Center for Advancement. So these organizations, before the implementation of NELA in 2014, each organization did their own intake process. So what that meant is JFUN, we only did intake on Wednesday afternoons from 3 to 5 over the phone. Catholic Charities, they only did intake the first day of the month. And Lutheran Family Services, you called and left a voicemail message and they returned your call. That's how they did intake. So what happened is Catholic Charities is a great example. People would travel from all over the state and stay the night in the parking lot of Catholic Charities to try to apply for immigration legal services before the first of the month. So to try to, and then people would just get shot from one organization to the other. So they'd have to do 5 applications to try to see if they qualify for nonprofit services. What NELA does is it streamlines the process. You can make one phone call and you're applying for all 5 nonprofit services within that one phone call. If a nonprofit can't help you, then you're sent a list of private attorneys that do immigration law, and those immigration attorneys have been vetted, so to speak, and so so you're a room for a full lawyer, so I don't want to say anything wrong, but so there's bad attorneys everywhere, right? There's a higher percentage of bad immigration attorneys than there are on the average. And one of the reasons is because our client base is more vulnerable to victimization and less likely to report malpractice or unethical behavior, right? If your clients call NELA and they're not able to obtain nonprofit legal assistance, the private attorney list that they're sent is private attorneys that have been vetted and don't have any disciplinary actions and things of that nature. So it's a great way to get started. If you're working with a kiddo that's undocumented, if you only do one thing, if you give them the NELA number, that would be a great start. Another important thing to know about NELA is anyone can apply for immigration legal services on the behalf of someone else. So I've actually had GALs call NELA on behalf of the child in juvenile court to try to apply for immigration legal services for the child. Lots of times when you're applying for things, it actually has to be the recipient that's doing the application. This is not the case. So as an attorney, as a concerned friend, neighbor, whatever the case may be, you can actually call NELA and apply for services for the child. You just have to know some basic identifying information about the child, which if you're appointed to GAL, you should know that anyway. Another cool thing is judges in Nebraska in juvenile court have started appointing attorneys to help the undocumented kiddos with immigration options. So that would relieve the pressure off you per se and put the pressure on the appointed immigration attorney to walk that child and also educate the court about the immigration forms of relief that are available for that child, which is really cool and not happening in every other state. So now we're going to open it up for questions. It doesn't just have to be about SIJ, it can be about anything. Is that the last slide? Okay. One thing that I wanted to... Right. So, like if the kids are worried about... Right. And so reunification may hinge on whether or not mom can get services and a job, right? Right. Department. That's a really great question. So the question is, if the kids were born in the United States and so they don't necessarily have an immigration legal issue, but if the parents are undocumented, what are we supposed to do? And I think what you said as far as immediate services is the right direction. You have to get the county court judge or the juvenile court judge to order specific services, and then the department has to comply because, like we talked about before, the department is not supposed to be providing services to undocumented individuals unless they qualify under a certain exception, right? And some of the exceptions are if you have an asylum application pending, or, there's exceptions if the woman's pregnant. There are exceptions, but for the most part, the state's not supposed to be providing services for someone who's undocumented. So what you do is you get the juvenile judge to order the services, and then you call NELA to see if there's any form of immigration relief for the mom. So if the mom was involved in some type of drug situation, and that's what you would need to screen for. You would have NELA screen for that, and you would have the immigration attorney screen for that. So if the mom had been the victim of domestic violence and she reported it, or she's willing to report it, a U visa may be an option. If the mom was married to a citizen or a legal permanent resident, a VAWA self-petition may be available. If the mom's afraid to return to her home country based upon something about herself she can't change, so say she was married in her home country and her husband was a domestic violence perpetrator and she's afraid to return to her home country because of that reason, then she may be able to apply for asylum. So what I think as an attorney for an undocumented person in court, just in any any court really, is referring them to get an immigration consultation is really important. Immigration law is really confusing, so they may have already had an immigration consultation years ago and think that they don't have any options, or worse yet, they may have been taken advantage of by a notario or an unethical attorney, and they've spent thousands of dollars and nothing ever happened, right? So making sure they get pointed to an attorney that's actually going to provide a quality consultation, I think, is very important. In your situation, there is probably some form of relief that could at least be explored for this particular client that would help her not only get reunified with her kids, but just help her be safe from falling back into that cycle. I think that's a really good question. Some forms of relief, you can get waivers for crimes, okay? So if we are thinking about a U visa petition or a VAWA, Self-Petition Violence Against Women Act petition, then there's waivers for criminal convictions for the applicant. Even in other forms of relief, so say this woman has a mother or father that is a United States citizen, that family member can petition for her, but since she may have a criminal conviction that may prevent a problem, so you'd have to look at a waiver whether or not that particular conviction is waivable. So the answer is it depends, but it's just because there's a conviction, it does not mean that there's no forms of relief available. There's one exception, and that's an aggravated felony, what we lovingly or not so lovingly refer to as the kiss of death, right? So if somebody is convicted of an aggravated felony, which is defined under federal sentencing guidelines, there's virtually no forms of relief that they're eligible for, with the exception of possibly U visa or VAWA applications. But if we're talking about most of the type of everyday convictions that our undocumented clients are facing, there's usually a form of relief or a waiver that's available for them.
Question from the webcasters. Are these SIJS orders only requested where the permanency objective has been changed by a court to something other than reunification or family preservation? In other words, does the entry of a SIJS order foreclose a family from being reunified?
That's a really good question. So it depends on whether or not reunification is, the plan for reunification is for one parent or for both parents, right? So if the reunification plan is to reunify with both mom and dad, then SIJ is not an option. If the reunification plan is only to be reunified with mom or dad, then SIJ remains an option, and the reunification plan, or the permanency plan, can continue to be reunification. It does not need to be changed. One thing that I wanted to talk a little bit about is just the priority enforcements, because we had a question about just what executive orders and what's that done. So the way that I understand it in my head is, like Rosangela said, there's over 11 million undocumented people in the United States right now, right? They don't have permission to remain in the United States. While being in the United States without permission is not a crime, it is something that you can get deported for, right? So immigration, deportation, removal, that's a civil nature. So being in the United States without permission is something that can trigger your deportation or removal. But if you think about it this way, there's 11 million undocumented people in the United States at any given time, but every year our government, or DHS, Department of Homeland Security, only has the funds to place 400,000 people into removal proceedings. So when you're looking at this large number, 11 million, and there's only room for 400,000 to be processed with a deportation or removal case, it makes more sense to prioritize people that are dangerous, right? And so that's, in 2014, President Obama really outlined the priorities to highlight serious criminal offenders, national security threats, and people that have recently entered the United States. So we're not talking about people who have lived and raised their family in the United States for a number of years. We're talking about people who have recently entered. That's how we operated for a number of years. Well, for a few years. And the new executive order has just totally shaken up the game, because anybody who's been thought to have convicted a crime is a priority for enforcement. Okay, so that's most of the 11 million. Entering the United States without inspection, especially if you entered in a group, will likely trigger a crime. So we're talking about anyone who didn't enter with a visa is now a priority for removal. We're talking about anybody who has just have some type of evidence that they may have committed a crime. There does not even need to be a charge, a criminal charge against the person. It just has to be evidence that a crime is convicted. So that's why anyone who's undocumented, it's so important to have an immigration consultation. One, to see if there's a form of immigration relief available for that person, but two, just to do some safety planning. Because we have people in our communities, in all of our communities, that are scared to go to church. They're scared to take their kids to school. They're scared to report crimes that may be perpetrated against them. And it's because the new executive order has basically said that if you're not here with permission, or if you're undocumented, that you're probably an enforcement priority. Because of the huge difference between the number of undocumented people versus the number of people that can be placed into removal proceedings, that's how DACA came into play, Deferred Action for Childhood Arrivals, right? So DACA was created by executive order, and it basically says that these kids that have been brought into the United States without any choice of their own, and who are virtually, they're as American as you or I, they're going to be given temporary permission to be free from the fear of removal or deportation for 2 years. They're going to be given a social security number so they can get a driver's license. In Nebraska now, they can apply for college. They're going to get work authorization so they can obtain employment. The reason that DACA was created is because of the power that the president has to prioritize people that are being placed into removal proceedings. Now, Rosangela talked about the 3 executive orders that have already been signed. There's been 3 other executive orders that have been leaked, not signed yet, but they've been leaked. And one of the executive orders completely does away with the Deferred Action for Childhood Arrivals program. It's not clear whether or not the people who already have obtained DACA approval can kind of ride out their 2-year deferred action period, or if it's invalidated immediately. But we do know that if that executive order is signed, then DACA goes away, and it's not an option for our kiddos. Because in addition to SIJ, DACA is something that we should be screening for when we have kids that are involved in juvenile court.
And we also don't know if those same DACA kids will be part of the priorities to be removed now. So we don't know if that information will transfer and all of these kids will be put in deportation proceedings. So that's the big worry for DACA kids too. In addition to fearing that it will end one day, they also fear that it will trigger deportation proceedings. Exactly.
And they've been updating their address every time they move. Yeah. So when we have clients that are applying for DACA, it's a really big decision. Not only is it expensive and it's time consuming, sometimes our DACA applications are hundreds of pages because it takes that much evidence that you're a person of good moral character and whatnot. It's expensive and time consuming, but it's also very scary because you're applying only for a temporary form of relief, and there's no guarantee that that information is not going to be used against you later. There is one little statement in an FAQ on the Department of Homeland Security's website, or USCIS website, that this information should not be used against the applicant, but there's no law and there's no other guarantee besides one little statement in FAQ that it's not going to be used against them. So a lot of our children right now, our DACA recipients, are really scared, in addition to many of our families that have undocumented people within the home. I think we have like 5 more minutes if anybody has any questions, and there's no question that's too simple. Go ahead, you're first.
Which jurisdictions are putting immigration attorneys for kids?
Which immigration, okay, the question was which jurisdictions are appointing immigration attorneys for kids?
The list that you talked about, the attorneys for immigration has provided, they do it by whatever the rate the county pays.
Yes, so the answer is it depends, like what is my answer for every single question you guys will ask, but I do know that judges are appointing immigration attorneys in Lancaster County and Douglas County and Colfax County. Those are the counties where we have actually been appointed as immigration attorneys, and it's the normal court-appointed rate that we get. What I've done in Colfax County, for example, to get appointed is an application will come through the NELA hotline by a caseworker, by GAL, whatever it is. I will reach out to the GAL first, and I will ask the GAL to submit a motion asking the judge to appoint an immigration attorney and letting the judge know that Justice for Our Neighbors is available to take that appointment. So that's what's facilitated Colfax County. I assume now that you guys know about this, that we can facilitate this in other jurisdictions by having the attorney for the child, attorney for the parent, the GAL, even the attorney, county attorneys, which by the way didn't want me to present to their CLE like you guys are allowing me to present to yours, but any of the attorneys can ask the judge to appoint an immigration attorney, and that immigration attorney can work through whatever form of relief that kiddo may be eligible for.
Is that just on 3As or is that
It's been on either 3As or 3Bs, yeah. That's a good question. Go ahead.
Are you guys giving any advice or guidance to people you come in contact with about ICE warrants, how to respond to those?
Yes.
And then, could you see the safety, you mentioned safety planning or removal if that happens, if parents are removed, and safety planning as far as delegation of parental rights and things like that. Could that be considered a reasonable effort or something in a 3A case, or do you guys just have a packet or something?
I think you could make the argument both ways. So the first question was, what was the first question? Know your rights? Okay, so what are we advising our clients regarding ICE warrants? And so that would kind of fall into what are we advising about what your rights are and what your rights are not. And the second question just involves what are we doing for safety planning, and do we have to do that? Does it have to be done independently and whatnot? So the first question about ICE warrants, that's a really good question. When we do Know Your Rights presentations, we talk about your rights as far as if you're driving, if you're a passenger, if you're on the street, or if you're in your home, right? And so the validity of the ICE warrant will depend on where you are in the scenarios that I just mentioned. The biggest thing I think that you can take away from this is the ICE warrant is not sufficient to enter in someone's home without permission. And so what we do, and we have a packet, and on your handout, there's a link to the NELA website. Under the resource tabs, there's a rights and planning packet that Rosangela and I put together. It's 200 pages, but everything is hyperlinked and there's a table of contents. So you can actually see an example of what an ICE warrant looks like. You can tell your undocumented clients that if somebody knocks on their door and they're not sure who it is, ask them to see the warrant, right? What has happened is you'll have ICE officers showing the ICE warrant and people will open the door. But the ICE warrant is not sufficient to enter the home. You have to actually have a warrant signed by a judge in order to allow the entry of your home without permission. The ICE warrants are not signed by judge, they're just simply signed by immigration officers. So that's in the Know Your Rights portion of the guide. In the safety planning portion of the guide, we actually have checklists for different scenarios on how a family or an individual can prepare for possible detention or removal. So if we have an undocumented person with children, whether the children are documented or not, there's a checklist of things that we recommend doing in case there is future detention or removal. And one of those things is a temporary delegation of parental powers. We also talk about we need to make sure if the child's a U.S. citizen, we need to get the child their passport. We need to make sure we have a copy of the birth certificate. If the child is a U.S. citizen, we also need to make sure we refer our families to the consulate of their home country to get that child registered with the consulate, so that way the child can return to your home country with you. If we don't do these things in advance, then even if the parents want to bring the children home to their home country, they cannot because they haven't prepared sufficiently for that. There's other safety planning things like where do you put your keys? Like you have to have an extra set of keys to your car and your house, and you have to have somebody that you trust that knows where that's. So just very common sense stuff that you and I maybe aren't doing on a regular basis, but our undocumented clients that are now at risk for enforcement need to start doing. So like I said, there's a link on the NELA website under the resources tab, and it's called Rights and Planning Guide. I'm also glad you asked that question because I can put my plug in. We are holding a train the trainer type presentation to teach you how to use the packet and go more into detail. You probably can skip the first hour because it's basically what I did, but the next 2 hours will consist of safety planning. That will be in Lexington on March 20th at Central Community College from 1 to 5 p.m. And then we are having one in Grand Island also, and that I will forward you the actual flyer because I don't have it memorized. But the one in Grand Island is March 11th. That one's sooner. But if you can come or invite people to come so they can learn about safety planning and how to better prepare people they come across, please invite them. I will make sure to forward that flyer.
And as you learned, there's not a form of immigration relief available for everybody right now. So sometimes there's nothing that an immigration attorney can do, but something we can all do is safety plan for the inevitable. I mean, I should have a temporary delegation just in case. So temporary delegation is only good for 6 months. So you have to, your safety planning packet has to be constantly massaged, right? And so if we educate our clients about what and how to do what they need to do in order to be prepared for the inevitable, that's at least one thing they can take away from a consultation. Does anybody have any other questions? Oh, we actually have a few more minutes. What questions do you guys have?
What about children that are older? Is there anything that we have to do special? I mean, they're not quite emancipated, but is there anything we should be looking at with children that are older that we should be doing differently as PALs other than just being faster on taking them in for immigration consult? Or
Yeah, so that is where I need more clarification about who's eligible for the Bridges to Independence program. But like Shante said, you have to act faster because you have to have that state court entered by the juvenile court judge or the state court judge before the child turns 19. It's okay if it's the day before their 19th birthday, but it has to be entered before the child turns 19. Then you have to submit the I-360 before the child turns 21. So once you get the state court order signed by the juvenile court judge, you have a little bit of breathing room. But sometimes, you guys know you're going to get assigned cases where the kid's almost 19. So you're going to have to act really fast to get that predicate order. Because if it's not entered and the child turns 19, SIJS is not an option for the kiddo. It's never going to be an option for the kid. Also, just screening for other forms of immigration relief for an older child. Yeah.
She then turned 19 and she was not eligible for Bridges until the T visa went through, and then she got to the Bridges.
That's a really good point of clarification. So a T visa pending is not sufficient for Bridges, but a T visa approval is sufficient for Bridges approval. So that's good to know. So with this same worker, I would assume that an SIJS petition pending probably isn't going to be sufficient then, and that you would have to have the SIJS petition approved before you could get into the program. That's really, really good news, though, because you can get the SIJS approvals regardless of whether there's visas available or not. So the fact that they're admitting people into the program with an approved I-360 is really good news, I think. Okay, so what we have a plug for is if there's any attorneys that would be willing to take a state court predicate case for an SIJ. What that means is we would do the immigration piece, or an immigration attorney would do the immigration piece. We do the I-360, we do the I-45, we do all that, but there would be a local practitioner that could get the state court predicate order. And specifically what this comes down to is like a guardianship or a custody divorce piece. And it's, you just proceed with the case normally. The only thing different is you have to get those 3 specific finding of facts included in your final order, or even in a temporary order. So you would get your normal order, you would just have some allegations of abuse, abandonment, and or neglect that is not in the child's best interest to return to their home country, and reunification with one or more parents not viable. I have a particular jurisdiction that I'm looking for. It's a family that lives in Sydney, so I'm looking at you, but if anybody ever practices out that way, I am particularly in need of help with that predicate order.
Or good referrals.
Yeah, good referrals. We also have we have a couple of really good programs that private attorneys can work with us to learn more about immigration law, but also to help our client base. We have a pro bono detainer project. That is where if somebody's been detained, they can fill out an application for pro bono assistance, and we will try to place a private attorney to help that detainee with their bond. And the representation would just be for the bond. You could end it right after the bond. So it wouldn't necessarily entail taking the entire case. Sometimes, as you guys know, immigration cases can take years, right? But the bond portion that we match people up with for the pro bono detainee project happens relatively quickly. And oftentimes we have clients that are detained in Grand Island or local jails that we can't get out to and do the consultation. So having private attorneys from other jurisdictions is really helpful. We can send that information on how to volunteer for the pro bono detainee project. And then we also have another really cool program called Attorney of the Day. That's where we've made a partnership with the immigration judges in Omaha, where they are only scheduling kid cases on certain days and times bunched together. And the reason is because we want to try to get attorneys representing every kiddo that's in front of an immigration judge. We just last month, I had to go to court with a 2-year-old, lift him up into the chair, give him crayons to use while the hearing's going on. And that's not uncommon. It happens almost every day. And you have babies, you have toddlers, you have junior high up to high school, you have kiddos that are unrepresented without a parent or guardian in the courtroom. They're at a table, the judge is up on the bench with the flags and the robe, and then you have the government attorney who actually kind of has an office in the courtroom. They have their computer, printer, pencil box, and so it's very intimidating. So we created this Attorney of the Day project to try to encourage private attorneys to come just for one day and represent kiddos at their hearing. And we've gotten the judges to allow just limited representation. So you do a very basic consultation before the hearing, and then you just go to the hearing with the kiddos, sit by their side, make sure that they understand what's going on, and then you can actually move to withdraw right after the hearing. So it's a very limited way of trying to give back. It's helpful if you're bilingual, but if you're not bilingual, then we can try to get an interpreter to help. But that's one way that you can learn more about immigration, because there'll be a JFON attorney helping you through the process, but also giving back just on a limited scope.
I also do clinics in Lexington. If you ever want to sit in and just do consults with me, it's a long night. It's from 5 to 8 p.m. one time a month. But if you ever want to sit down and just learn about immigration law, I'm more than willing to bring you on. I know we've done it before and it's worked well.
There's a significant shortage of immigration attorneys in central and western Nebraska, so if it's a practice area that is of interest to any of you, we would be happy to talk to you more about it and actually mentor you or hold your hand if you want to just try a case. Shante, do you want to talk about that at all?
How helpful you guys are?
Yeah. Tell them how good we are. No, tell them about immigration, adding immigration law as a new practice area.
Well, it can be very overwhelming to add completely new practice areas, especially something as complicated as immigration. And in the words of these two ladies, I don't think I would be at it for 2 years that I could start taking the kinds of cases that I'm taking. I assisted with my first SIJS case. That was a referral from them. I did the state court predicate order. It was very simple. They had all the information to help walk me through from the consult to get the right information I need in the juvenile's statement declaration, all the way through to applying for the permanent residency before 85. So, and I know they've worked, and so then I know how to do that and more familiar with that. So then when my name pops up and somebody shows up from, a different county, they need that. I actually have experience to do it and been able to kind of provide that service with still some assistance occasionally from them, but it is helpful. There is a great need up here, and I think just in the last month, I have had more calls than I've had in 2 years. So with immigration.
So I don't know if everybody online could hear, but Shante, basically we kind of strong-armed her into taking an SIJ case. She did the guardianship, got the predicate order, she filed the I-360 and the I-45, and we were there to help her along the way. And it's not completely altruistic on our part because now we know that there's a local practitioner in this area that can help our kiddos that need that state predicate court order. So if anybody's interested in bringing in at least SIJS cases, they're very rewarding cases and they're not that hard. I mean, yes, it's going to pull on your heartstrings because you have to get some sad details about very, very sad situations. But as far as procedurally, you know, we've kind of done a lot of the work already and we have it streamlined. So if anybody's interested, please let us know.
I did have one question about abandonment. So have you had this come up with, I think a lot of our juvenile court judges kind of see abandonment in the context of a termination proceeding, but with SIJ, you can make an allegation of abandonment, abuse, or neglect. So have you had it come up, are we able to bring up the issue of abandonment of one parent, maybe a parent that's not in their lives, way before we get to a termination process in the juvenile case, in order to get the state court predicate order and move towards the SIJ status? Or should we be waiting until termination is being brought up for that parent that's completely out of their life and has never had contact?
Right. That's a really good question, and I think a lot of juvenile court judges are confused by that. So abandonment does not have to be akin to termination. So let's say that the child was never subjected to abuse or neglect, and the only applicable piece for the SIJS case is abandonment. Say dad abandoned right after birth, or dad abandoned while mom was pregnant. That is still okay. You do not have to terminate dad's rights. However, you just have to make sure the judge is comfortable making a finding of fact that dad abandoned, and what you do is you don't use the termination statute, you use a criminal statute to define abandonment, or you use case law. So you have to do whatever it takes to make the judge comfortable with making a finding of fact that the dad abandoned. You do not have to make termination a priority. You do not have to make termination a prerequisite of your predicate SIJS finding. Go ahead. Yeah, that's a good question. The question is, can you get the SIJS predicate order at a permanency hearing? And the answer is yes, and actually you could also just force a hearing to specifically have the SIJS order entered. Remember, we're not calling them SIJS orders, but if you want to have a review hearing that, you know, say your permanency hearing's not for a while, you have a kiddo that's 19, you just schedule a review hearing and you ask for the order with the SIJ predicate findings at that hearing. Go ahead.
Okay, so staying in the TV, the girl, we thought that so she had a good path on the TV, so meeting the immigration attorney, but that also SIJS might have been an option, but we were pre-adjudication in the way that the petition had been filed. It was a no-fault petition, so we were concerned that getting a no-fault petition would make the predicate order contradicting with the adjudication, or with the, and then
Right.
also with the potential for mom to come over, because mom was still in Guatemala, to come over under the TV, so we were worried about getting a finding that she was abused or neglected. And then I think we kind of ended up finding out that didn't really matter that much, but what are your thoughts?
Right, so I think the one thing to remember is if the kiddo does want to someday be reunified with mom and dad, then SIJS is not an option. If the kid wants to be able to petition for at least one of the parents to enter the United States, SIJS is also not an option. So sometimes, like, a kid that's 13 years old, they have to make a really, really difficult decision about whether I proceed with SIJS as a form of immigration relief and never be able to petition for my parents, or do I try to file for asylum or some other form of relief. So that's a very difficult decision. But once it's been made, you can never take it back. So if the child obtains their SIJS approval, they can never petition for their parent regardless if they had other applications pending, right? However, if you have more than one application pending at the same time and you withdraw your SIJ application, then the child could theoretically petition for the parent in the future. Now, as far as when to get the predicate order, before adjudication or after, you're going to have to work with the parent's attorney in that regard. You know, if it's a no-fault petition, then you have to weigh the pros and cons of making certain allegations. So in that situation, the judge is probably going to want testimony of the mom since she's involved in the proceedings, right? So is she going to be testifying to something that is detrimental to keeping the case a no-fault case? I don't know. I'm not a juvenile court attorney, so you would have to really work as a team to try to figure out whether or not you should try to get the predicate order before adjudication or not, right? The thing about the T visa is, like we mentioned before, T visas, U visas, and VAWA applications are the forms of relief that you can typically overcome criminal convictions. Even though a SIJ predicate order would not be a criminal conviction, it would just be a finding of fact, I still wouldn't be very worried about it interfering with a T, a U, or a VAWA self-petition, right? But there are forms of relief where you have to prove good moral character. And so if there is a SIJ predicate order out there for mom or dad that makes allegations of abuse, abandonment, neglect, then that would be something that you would want to consider.
Especially at the citizenship level. That's thinking far along, but that'll be taken into consideration then.
So you really want to carefully draft your predicate order. So especially if it's a one-parent SIJ case where you're making abuse, abandonment, neglect allegations about another parent, you want to be really careful that you're not making any statements or declarations in your affidavit or on the stand about anything that could implicate smuggling or anything that could implicate anything that would deteriorate their good moral character findings down the road. But like we said, we're more than happy to review those predicate court orders to try to prevent things like that from happening. Did you have another question? No? Oh, I know what. Abandonment can also be found effective abandonment through death. So if you have a kiddo that both parents are deceased, originally we thought that SIJ would not be an option because you couldn't, if abuse, abandonment, neglect had not been an occurrence before the parents died, we thought maybe it wouldn't be an option, but we have been able to get SIJS applications approved by effective abandonment by death.
My name is Ann Payne. I'm a county judge from McCook. I actually have 4 counties I cover: Red Willow, Furnace, Hitchcock, and Hayes. But I'm in the 11th Judicial District. We all cover for each other there. Judge Turnbull was just here and just left, but we all cover for each other in the different counties in the 11th Judicial District. I've been a judge for almost 10 years. In July it will be 10 years. Before that I was an attorney in private practice. Started out with my father for 4 years after he passed away, then was on my own for about 15 years, so altogether about 19 years before I became a judge. Did a lot of work in juvenile court, a lot of representation of children as a guardian ad litem. Also did a lot of representing parents in juvenile court proceedings, that type of thing. So I've had a lot of familiarity on both sides of the juvenile court proceedings. But I'm going to apologize in advance. I came down with a horrible cold yesterday, so I'm not 100%. My voice is a little shaky, but we're going to power through today. So I was asked to speak about guardian ad litems. That's a pretty broad topic. She just kind of left it up to me as to what I wanted to speak about. So I think that what we're going to do today is I'm going to talk about the Supreme Court rules for guardian ad litems in juvenile court proceedings. And then I'm going to open it up to I've got some questions that I have posed here that I'm going to open it up to discussion. My hope is to get some discussion back and forth with you about some situations that you have and maybe questions that you have in your representation of juveniles in juvenile court proceedings. In 2007, the Supreme Court put together what they called or passed, I should say, the Supreme Court guidelines for guardian ad litems in juvenile court proceedings. They were put together by a subcommittee that spent hours looking at other states and put together these guidelines for guardian ad litems in juvenile court proceedings. They were intended to be best practices. There was no sort of disciplinary action if you violated those guidelines. They were never adopted as rules until LB 15 came along in 2015 and required the Supreme Court to come up with standards for guardian ad litems in juvenile court proceedings. So on June 24th, 2015, the Supreme Court passed the practice standards for guardian ad litems for juveniles in juvenile court proceedings, which pretty much just adopted the guidelines that we had before as our Supreme Court rules. The standards are divided into different sections. Section 1 is the purpose, and the purpose, of course, is to provide for the best interests and legal representation of juveniles in these types of proceedings. The appointment is the second section, and a guardian ad litem in Nebraska is to be a lawyer, and it talks about that the duties should not be delegated to someone other than the lawyer, such as staff or legal assistant. You're supposed to do your own interviews, go talk to the children, the foster parents yourself, do all of that type of work yourself whenever possible. And the guardian ad litem must complete a specialized training in Nebraska. I was on the subcommittee that helped develop that training, that special education just for guardian ad litems. It's designed to be a very nuts and bolts training to give you information on exactly what you're supposed to do once you're appointed, how to write a report, how to visit and talk with those children, all those things that you're supposed to do. The role in Nebraska, the guardian ad litem has a dual role, and that's been argued back and forth for years as to whether that's the best thing for a child or not. But in Nebraska, that's what we have. Guardian ad litem looks out for the best interests, like a parent, and also is legal counsel for the child. The rules provide that if there is a conflict in those roles, that you can ask, as guardian ad litem, you can ask the judge for a separate legal counsel for the child. I'm curious, has anybody ever done that? Okay. In all instances, did you get a separate lawyer?
Well, I get appointed as guardian ad litem on, I don't do 3P cases, I just get appointed as guardian ad litem on those, and it's almost always a different. So I've had one every time I've asked for it. Because the child almost always wants something different than what I think is covered.
Anybody ever have a judge deny that? I did that with a guardian ad litem. I didn't do it a lot, but I had maybe done it a handful of times. And in every case that, as a judge, that an attorney's asked me for that, I've always appointed a separate counsel, because I figured that if they are to that point that they feel like there's a conflict, there probably is. There's specific factors that the guardian ad litem can weigh that are put into the rule: age, capacity, level of maturity, nature of the inconsistency between what the child stated that their preference is and what the guardian ad litem believes is in the child's best interest. So if you believe that you can't represent both things anymore and that the child has some legal interests that have to be represented, just ask the judge for that separate attorney. The next section has to do with the authority. That's very important as a guardian ad litem, to make sure that you get access to everything that you are supposed to have access to. Access to information, communication with the parties, and then their rules provide for sample language to put into a court order to get you all that information. I don't know if you have had difficulties. Anybody had difficulties getting information? I don't generally. When I first started in practice, there were some people that maybe had difficulty wanting to give that information out. Anymore, I think people are pretty much used to the fact that guardian ad litems get everything. So I haven't had much trouble with guardian ad litem's coming in and asking for specific orders to get information. Next section is, of course, the one that everybody has the most concern about, is the duties. First part, it has to do with consulting with the juvenile, which says in person unless impracticable. And then under that section talks about at all times specified by the Juvenile Code, which is section 43272.01, subsection 2D. Anybody tell me what that says? Anybody know? You're supposed to visit within 2 weeks of being appointed, and then every 6 months, at least every 6 months thereafter. That's the bare minimum. So, and as a judge and as a guardian ad litem, I would say that's the very bare minimum. 6 months is a very long time to go without visiting a child, but that's what the statute says. So at all times specified by the Juvenile Code is the first part. Whenever the juvenile requests, when notified of an emergency, prior to a hearing with substantive issues, in every placement at least once. And we're going to talk about that in a little bit, how important that is to visit them in their placement. And if it's at a long distance, if there's a geographical problem, you can ask the court in advance to approve expenses. Has anybody ever done that? Okay. Did you have any problem getting that approved? Yep. Yeah, I've done that as well. I did, first time I ever did it, I had to go all the way to Topeka, to another state, because she'd gone there on a visit and then never came back. And so then the judge was trying to decide, are we just going to close the case, or do we need to go to all the trouble to try to get the child back? And so I said, well, here's what my expenses would be if I went down there and looked, and she was living with a convicted sex offender, there was marijuana in the house, all sorts of other problems. So it was a very good thing that I had gone down there. But yeah, you just list what your mileage is, all your expenses, and submit that to the court in advance. And I've had people do that as a judge, and I think I've approved it every single time. So unless it's outrageous, most of the time you want the child to be visited in that placement. And then the rule defines exceptional circumstances for you. And inquiry, who to talk to. When you're a guardian ad litem, who is it important to talk to? Who do you guys visit with? Obviously the caseworker, foster parents. Who else do you think it's important to visit with? Counselors.
Doctors, counselors.
Yep.
Teachers, Spanish brokers.
Yep.
Parents council.
Yes. Other attorneys. All those people are very important before you write your report. And what reports do you want to review? Obviously, the case plan. There's an IEP, those sorts of things, any sort of school reports. Grade reports.
Family advocacy.
Right. Now we have the nice school information forms, those sorts of reports that come out. So all of those things are helpful. Then you're required, of course, to make a report to the court, and that has to be, you have to give a written report at every review hearing, and starting at the disposition and on all the review hearings after that. Hopefully all of you are doing that. Is everybody writing written reports here? Okay.
There's one new requirement in those reports. I'm not sure what, I know the new form has it, but there's something that has to be in the reports so that the services can continue or something like that. Is it, you know what that is? Yes. That might be good.
Judges have to make rulings regarding reasonable efforts in order for 4A funding to continue. If that's what you're talking not aware of anything in the...
Form didn't comply, so I had to change over to the new forms on the...
Yeah, the rules provide the actual forms, the recommended forms that they want you to use is actually attached to the rules as an appendix of the actual guardian ad litem form that they want you to use. In it, you have to talk about when you visited the child and all those sorts of things, people that you consulted with. Gives a lot of good information to the judge as to your basis for knowing what you are recommending for your child. It's also a protection for you, I think, as a guardian ad litem, because it tells everybody what you're doing and how you're working on behalf of that child and protecting that child and the efforts that you're making to make sure that child is safe. So I think it's a good tool not only for the child but for you and for the court. You're supposed to participate in all court proceedings and testify to the extent allowed by the rules of professional conduct and provide quality representation, no excessive caseloads. What that means, nobody really knows for sure. Nobody has really tried to define that. Probably it's impossible to define because I think it depends on so many variables, depends on what other types of cases you're handling, your geographical distance, your hours that you're putting in. There's so many things that go into that. But I think you will know if you're getting too many cases. I've had guardian ad litems come to me and say, even guardian ad litems that are under contract with the county and say, I can't take any more cases. I am too far. And I say, okay, no problem. I'm going to appoint somebody else because I don't want them taking on more cases than they feel they are comfortable with taking, because that doesn't do those children any good. Termination, they're supposed to be continuing on in that case. Guardian ad litem means that you're a guardian for the case, so you're supposed to continue on until released by the court, until after filing a motion to withdraw or removed by the court. You can be removed for cause. Doesn't happen very often, but the court can remove you for cause, or you can withdraw and the court can release you. And compensation is the last section, and for those not covered by multi-case contracts, the Supreme Court may establish uniform minimum hourly rate of compensation. Has not chosen to do so yet. All hours should be reimbursed, including travel time. I think most places are doing that, as far as I'm aware. So, those are the Supreme Court rules. Some of the questions that I want to throw out to you are, what steps can you take if your child is placed in a group home or foster home across the state? What are you folks doing to visit that child? Okay. Okay. They're saying phone calls. What else?
Planning around another trip. Like East Interstate or something.
Okay, so if you're already going on a trip anyway, stop and visit the child. What else? Out here in the rural Nebraska, it's a problem. I mean, sometimes we have kids placed in group homes in Omaha.
It is a problem out here, especially because some of those services are a long ways away from us. Like Boy Scout, for example. I've had several juveniles placed in Boy Scout in Omaha, and they always have an opportunity to get to Boy Scout in Omaha and visit those kids. So if they're older, you can talk to them. That's
Right. Yeah. If they're older, you can talk to them on the phone. You can Skype with them. You can FaceTime with them. Some of those things. You can email them, talk to them that way. One of the things that you can do, you were talking about at Boys Town, if you have a child placed at Boys Town, even if you don't have a child placed there, when you talked about going there if you already happen to be there anyway, some of those facilities, I don't know how many of you have toured different facilities around the state if you just happen to be there. But it's kind of a good thing to know what those facilities are like if you're going to have children placed there. I don't know how many of you have toured YRTC, but it's an interesting place to go if you have never been there to see what that place is like. Same with Boys Town. I attended a graduation there one time just because I wanted to see and got kind of a tour of the campus, and you get a feel for the tone of the place and Holly and some of those places. If you happen to be there, even if you don't have a child there, it's nice to know what the facility is like, and it's hard to get a sense of that on the phone and just reading about it. But those are some of the things you can do. One of the other things, and I've never had anybody do this, but I've always wondered about it, is if you have a child placed a long ways away, especially if it's a minor child that maybe you can't talk to on the phone, I've wondered about having a request to have somebody appointed in that area as a guardian ad litem that you could communicate with even, or something so that you could have eyes and ears there, perhaps. Might be a tool to use. I don't know if anybody's ever done that. Anything else that you guys are using to communicate with a child that is ways away?
This is probably more so in like 50 cases, but Jabber.
Okay.
That's a
okay. Using Jabber to talk with a child. And maybe even if you don't have the facilities yourself, as a court can set it up, if they have those facilities, and you can stay after court or before court and talk with the child. And obviously, if the child's coming back and forth to court, and that's another question I have, how many of you require, why do you think it's important that the child comes to court?
Yeah, to understand what is happening in that child's life. I get it with the really young ones, it doesn't make a whole lot of sense, but I remember it was a seminar several years ago where they had a bunch of kids that had aged out, and they came to talk to, it was the 3-day seminar, I think, they came to talk about not knowing what was happening in their lives. They were told what happened afterwards, and that was very disturbing to them because it felt like everything was happening to them without any sense of control. So I think it's important for kids to come and understand, even if the process has been boring.
Yes.
To understand what the judge looks like, what it's like when your parents are sitting up at the table, all of that.
Okay. Most of you agree that it's important for kids to come to court?
I think another perspective is sometimes you're talking about this child and they're never there in court. You just, well, we're doing this. The casework will talk about that type of thing, but I think once in a while it's good to have subject matter.
Yeah. See an actual face of somebody who's actually involved, that it's a real person that we're talking about here. Yeah.
What's your view? I have a lot of kids, especially older kids, that don't want to come to court, and a lot of it's because they were the ones that made the allegation, and their mom and dad are going to say hurtful things. So I always ask for those kids to be excused, but I think at a certain age, if they're not comfortable, I don't want to force them into that situation.
I can tell you that usually I always want kids to be in court unless the guardian ad litem tells me that they think the child should not be in court. That's the one time I say kids don't need to come to court, is if the guardian ad litem is telling me this is not a time for them to be here. That's the one and only time I don't have kids in court. I even have little teeny tiny kids in court. And let me tell you, when you talk about being disruptive and whatever, sometimes it's difficult to make a good record because it's loud and noisy, but I get to see things that I wouldn't know otherwise, because when they're crying or upset or whatever, I get to see who they go run to, who's comforting them, and how they interact with that parent, or what's happening, what that bond is like, some things that I wouldn't see otherwise. And so that is important to me, even those little subtle things that you wouldn't get to see otherwise. That's the only time I get to see that child, is in court. And it might be one of the few times that the guardian ad litem gets to see the child, especially if it's an older child who's placed a ways away. That may be one of the few times you actually get to see and talk to that child. So I think it's very important, and like somebody else said, I've heard older kids in foster care review panels talk about the fact that they didn't get to come to court and all these things were happening and they didn't know what was happening and things were being done to them and said about them and they weren't there and didn't have a say, and it makes them angry. So, but there are exceptions to that. Some kids are different. Some kids are very shy, withdrawn, and are terrified of court. So we try to make it very non-threatening when they come and make it a pleasant experience. Yeah.
Do you start hearing sometimes with the kids present, and then if there's going to be testimony
Yes.
regarding
Yes.
that particular parent or allegations that excuse the kids?
Yes. We sometimes have like CASA workers or something take the children out in the hallway, or I wish we had we've always wanted to have a separate room that was kind of a kid-friendly room to take them to if there was things that they didn't need to hear, but that's not happened. But we do have, CASA's provided for us some bags that have like toys and colors and things for them to work on, and so we keep that in the courtroom and they have some things to play with while they're there, because sometimes it can be a long drawn out process, but yeah, we have had them removed. That happens frequently if it's a different, and some things like if it's a contested adjudication, there's no reason for little kids to be there probably for those kinds of hearings.
Well, I shouldn't say every once in a while, I think it happens more times than not. With the older kids during the school year, our courts here aren't all that interested in having them miss school to come hang out in the packed hallway and the tiny courtroom. So I guess I don't even know exactly what my question is. It's just, is that a viable excuse when we have kids who aren't necessarily doing well in school to not be coming out to court but staying in school?
I think it depends on the situation. If the child is really struggling in school and maybe, if truancy was the basic problem and all we're doing is pulling the child out of school all the time to come to court, that's probably not a good solution. But depends on the situation. I usually try to have court coincide with, for those older kids, especially truancy kids, after school. Can't always happen, but I try to make it after school or at least toward the end of the day so they don't miss much school. But I guess those situations are case by case basis. But yeah, you don't want them to miss any more school than they have to. That's for sure. Another question that I had for you, and that kind of gets back to what we talked about earlier, the importance of visiting a child in the foster home. I can tell you, I'm just going to give you two examples when I was guardian ad litem of times that it drove home to me how important it was to visit a child in a foster home placement. I had a couple, they were together, a husband and wife, and they had a young child. She was, I think, about 18 months old, and they didn't have a solid home. They were moving around place to place with whoever would take them in, basically. And they had been in a house in Arapahoe for maybe 2 or 3 weeks, and the caseworker still hadn't been to the house yet, hadn't been able to make arrangements to get there. I'd been trying to get a hold of them, and they kept dodging phone calls or something. Anyway, I was getting really nervous about this, so I just up and went and drove to the house one day, banged on the door. It took them a long time to get to the door to answer and let me in, but they finally let me in. There was animal feces all over the floor. There was 3 or 4 children, I don't remember exactly, and a playpen that had holes ripped through the side, so there was like choking hazards. There was exposed wiring on the walls. Before I left, I was calling the caseworker as I was driving home and said, you get that child out of there now. So, I mean, those were things that there's no way that I would have known that had I not been there. And I don't know how long it would have taken for the caseworker to get there. It might have been okay, might have been all right if she would have stayed there, but I don't know that. So that was just one circumstance. And then I had another case where I had a boy, I think he was about 14. His mother had been doing drugs for years. His older sister had basically been raising him. And he had been in a foster home. He and his sister were separated, and I don't exactly remember why. But he'd been in a foster home in another county, and this was a foster home. She'd been a licensed foster mother for many, many years. All the right credentials. She'd been doing it a long time. I talked to her on the phone many times, and we talked about the boy and how well he was doing, but he just wasn't thriving. He wasn't doing well. He didn't seem happy, and I didn't understand what was going on. And I had talked to him on the phone. I'd seen him in court, but I hadn't gone there. I finally went there one day to visit, and he was actually in school. He wasn't even there. But I sat down and talked to the foster mother upstairs, visited with her, and it was very strange. She was just kind of cold and talking about him, about the chores that he needed to do and those sorts of things, and very just kind of unfriendly about it, but just more like it was a business than anything else. And then I went downstairs, and because I asked to see his room, and she had 5 other foster kids in the home, and there were these little twin beds just all lined up like military fashion. And I, the next week, filed a motion for change of placement for him because, you know, and maybe other kids would have been fine in that sort of circumstance. This was just not for him. There was no bonding or attachment or feeling or emotions there at all, and he was just not doing well in that environment. And fortunately, because I didn't really have a good reason for change of placement, because she wasn't doing anything bad to him or neglecting him or anything else, providing everything that he needed. But fortunately, that judge knew me well enough to know that I wouldn't be asking for a change of placement unless there was a reason for it. And he got moved to a foster home in Beaver City. After that, he just absolutely thrived. He was a musical and talented kid in drama and whatever, and he was doing all of these things in the school and just flourished. And they took guardianship of him, and he did fantastically after that. But it was one of those things that you just had to get that sense of being there and seeing that foster home, and I would have never known that had I not been there. So those are the kinds of things that I think are important to see in the environment. So do you guys have similar experiences? Why do you think it's important for you to be in the foster home?
Quite often there's much different story about what's going on in the foster home between the times parents have visits in the foster home and what they say is going on versus what you can observe yourself as far as foster parents parenting and bonding and disciplining and basically managing child and children, and yet then in a team meeting, well, the parent says, well, they don't treat my kid right. They're making them do this, make them do that. And there's often conflict, and the only way you can resolve it is to have some personal experience and see what's going on.
So the only way you can really get the true story from all the different versions from the parents and foster parents and caseworkers is if you see it yourself. Yeah. Yeah.
I think sometimes the foster parents too, I usually like to try to chat with them separately because I think they have insight that nobody else has, even if a lot of times the counselor is new on the scene and the case is just open and they really the only adult the child trusts, if it's a good relationship, is the foster parent. And so they can provide a lot of insight into what was happening or how visits are going or how things go after visits and things like that.
Yes, foster parents are a huge source of knowledge. Absolutely. God loves foster parents. I mean, they're taking children that have been abused and neglected and are with them 24/7 and having to deal with all of the aftermath of that and the ups and downs of visits and back and forth with parents. So yeah, they are a tremendous source of knowledge. So if you can pull them one-on-one, that's absolutely a great source.
How do you deal with issues where maybe the caseworker is addressing things in a different fashion than maybe the guardian ad litem thinks they should be.
Okay, the question is, how do you deal with situations where a caseworker is dealing with a situation differently than the guardian ad litem thinks you should? What particular type of situation are you talking about?
Oh, it may have something to do with, on occasion, marijuana use or something like that. We're talking about a kinship type placement or something maybe, where there's some things that go off the kinship placement that aren't necessarily what you would like to see, that they're kind of glossed over a little bit.
Okay, so the question is, if it's in a kinship placement and maybe you're saying that maybe that there's something going on in the kinship placement and it's being glossed over because the caseworker doesn't want to blow that placement? Is that what you're saying?
Kind of, yeah, I guess that's kind of what I'm getting at. And there's other circumstances too, but that would be, I guess, an example.
I think it's your responsibility to advocate for the best interest of that child. I can tell you, when I was guardian ad litem, there was several times that I butted heads with caseworkers. Yeah, I think you don't want to be in an adversarial position, and I don't think that's the best place to be, but there are times when your role requires that, I think. If you think that there's something happening that's not the best thing for that child, I think you've got to stand up and say, no, I don't think that should be happening.
A dynamic to that is when you have a new caseworker who doesn't have the experience to have just a sense of security about what they're doing. And so they're not being as critical or as, let's say, forceful. I got to remind myself, I'm not a caseworker.
Right.
And so I've worked with a caseworker supervisor. Again, it's like, I'm over it. It's like raising a child. You really don't want us to be criticizing your child in front of other people all the time. And so working with a supervisor to try to get that caseworker to think a little, in a little more structured fashion, or whatever it is you're trying to do to help work the best interest of the child. But I have to remind myself, I'm not a caseworker. It's not my job.
Best case scenario always is for the team to be working together for the best interest of the child. Always. That's always the best case scenario. But if you really think that there's something going on that shouldn't be happening for that child, clearly I think the first step is you go talk to the caseworker and voice your concerns and why. But you have to have reasons for that. I mean, you have to have the knowledge and the understanding and have kind of documented why you think that it should change. And then if not, then you file your motions and you bring it before the court. But I think it's your responsibility to make sure that the child is looked after, even if it ruffles some feathers.
Actually, the daycare provider reporting to me directly as guardian ad litem because they didn't think they were getting they thought there were things going on with the visitations and parenting that weren't necessarily appropriate. And the department wasn't really very receptive to I guess, bringing that to their attention. So,
well, and if you're getting reports from other parties, I suppose then you have to sort of meet it out and try to find out what's accurate. But yeah, I think you got to report that to the caseworker and ultimately maybe the court and find out what's happening. So, kind of along those lines, one of the other questions I wanted to throw out to you is, what do you think about visits for children with substance abusing parents? That is a big issue because different people have different views about that, I can tell you. I'm not going to say that any of them are right or wrong. But we have many, many cases anymore now where the primary issue is substance abuse of the parents, and so we're dealing with that on a constant basis.
What's your policy?
Well, I can tell you I was at a training one time where one of the doctors that was putting it on said these children grew up in a home where they're used to seeing their parents using substances. This is not something new to them. They are well aware that their parents are using drugs and have seen their parents under the influence before. This is not going to be a shock to them. That in and of itself is not going to damage them. That being said, clearly, if there's some harm coming to the child because of that, some of the parents can get completely out of control. I mean, clearly they would have to be a supervised visit, I think. But I don't know that using it as a punishment to take away visits is a good thing, because I think that is a punishment to the child as well as the parent. And I don't think punishment is where we should be at. We should be trying to get the family back together, and visits are the only way you're going to bring that family back together. So my policy is probably, in some cases I've had guardian ad litems come to me and say, if they're high that day, test high that day, I don't think the visit should happen. Depending on where we are in the case, there's so many variables. Depending on where you are in the case, if you're almost at the end of the case and about ready to terminate parental rights because we've been 2 years down the road and we're still using methamphetamine every single day, that's a different circumstance to me. But and it depends on how young the child is. It depends on if the visits are being supervised. It depends on if the child is being upset because mom is under the influence and they know that. But if it's not affecting the child, if the child misses mom and wants to see mom and mom can still handle herself and the visit's okay, I mean, it depends on what the substance is. It depends on how but if they're highly intoxicated and can't handle the visit, then absolutely no. So there's so many variables. It's hard to say. But you as guardian ad litem are going to have to make those recommendations, I think, to the judge based on all those different variables. But number one is how the child handles it, and whether it's having a negative effect on the child or whether the lack of visits is having a negative effect on the child.
Judge, what's your opinion of, from the outset of the case, parents testing positive for methamphetamine, no contact, no visits, and we're starting the case at the beginning with zero contact with the child? What do you think is the best practice from a GAL perspective regarding that request from either the department or the prosecutor? That absolutely no contact occur until a parent tests clean. For weeks. For weeks. A month. That's the approach. That's where we're stuck at in this county right now.
If you engage the
Not to pass this.
I think it's hard to develop bonding if there's a long period of no visits. I think that's hard to maintain and develop bonding when there's no visits for long periods of time, myself.
You think it's going to be, from a judge perspective, the parents that are struggling with substance abuse issues, is there a better likelihood of success that they're going to cooperate in order to have visit? Or do you see the alternative, they just completely walk away from the case because the only thing keeping them engaged was contact with their child? I mean, have you seen it go both ways and equally, or?
The question is whether a parent is more likely to comply with the case if they're getting visits versus if they're not getting visits, that they might just walk away. I can tell you with substance abuse, especially methamphetamine, it's anybody's guess. I've seen both. I don't know that I've ever had that long of a period of time, though, ever, even with substance abuse methamphetamine without offering visits. Ever. Usually we offer visits. A lot of times they'll walk away from them. So I don't know that I've ever, as a judge, been in a situation where we've not at least offered the visits for that long of a period of time. But quite often they'll walk away anyway. It depends on where they are in their use, that they just decide the drug is more important to them at that particular time. So I don't know the answer to your question.
Going back to what you indicated before, isn't it really with the team? If you have a functional team, and the children, if the children or your client have been showing behavioral problems, and get them in with the counselor dealing with children who have been traumatized, and mom and dad are into some kind of rehab program, whether it's 30-day program, outpatient, or whatever, and as long as the process, there's going to be a relapse in the drug users, that the team makes that assessment in effective safety of the child and efforts for and says, all right, you've been positive now 3 times in the last month. You're rational in your visits, but I guess that's where I am so much on the team, but for all members of the team.
Okay. Well, and the comment for the people listening is that it's a good idea for the team to be making those decisions about visits and how those visits should occur, because all that the input then as to how it's affecting the child and moving forward with visits. And I always like to get that input. As a judge, I like to get the information from as many parties as I can as to what's best for that child in terms of visits. I'm always concerned as a judge, I want you to know, that if we get to the point of termination of parental rights, somebody's going to be reviewing the fact that I gave this parent all the reasonable efforts possible to try to reunify with this child. And so I want to make sure that I gave this parent every chance possible to try to get their child back. So I'm always pretty cautious about limiting visits unless there's a good reason not to have visits. So part of that is to err on the side of caution, because I don't want to be way down the road in the process of a termination of parental rights appeal and have them say you didn't give this parent all the rights that they were supposed to have to try to get the child back, and so now essentially you need to go back and start again. That being said, I want to protect that child as well and make sure that they are protected and not having trauma in visits because they're seeing a parent under the influence. One other question that I was going to throw out, foster care review board reports. Are you guys all participating in that process, filling out the questionnaires or sending in the stuff? Nobody's, I see yes and no.
Yes.
I call.
Okay.
And then I send my GA reports.
Okay.
They already have it though, because they have access to the file, right? So I assume
Yeah.
that they have it. If it's a big case, if there's an issue, I'll make it known that there's the issue, but rather than that overview.
I just think it's important. I felt like that when I was a guardian ad litem, that, I mean, they're kind of an overseers of what we're doing, and I guess I just never wanted to have a black mark to say that I wasn't doing my guardian ad litem job. So, or somebody else saying on my behalf that I wasn't doing something and not having a say in that. So
There are a group of individuals who have a particular purpose, and they're very diligent about doing the proper assessment.
was my thought. I just didn't want anybody speaking for me. I wanted to have them have my views rather than just somebody else's views. So, what about youth questionnaire forms? Are you guys using those? Even the younger kids?
Our CASAs handle that in Castle County law.
Yeah, that's what we're doing. Is our CASAs give them to the kids, and I get those quite a bit. I love those as a judge. Those help me tremendously because it gives me a real insight into little kids that sometimes won't talk to me in court. I usually try to engage the kids in court and talk to them a little bit. Sometimes they're very shy. And number one, it'll tell me things about those kids that they maybe won't tell me in court. And second of all, it will maybe give me a clue as to something I can start talking to them about. It might tell me something they really like, and then if I start talking to them about that, then they maybe will open up and visit with me a little bit in court. So those things help me a lot. So if you aren't using them in your courts, I would certainly suggest that you do that because I think it will help you as well as the judge kind of have some insight into those kids. What about the caregiver information forms? Are you guys getting those very often?
I know those get turned in by foster parents that tell me that, but I don't ever get copies of them. I can just go to the judge.
Okay, you guys don't see them? They don't use them as exhibits or anything?
Yeah, those exhibits. I think they're not sealed. You can see them. They certainly are not turned in. I would say the majority of cases here, maybe like 1 out of every 10 cases.
Okay. I was just curious because I think different jurisdictions are doing that differently. In our area, they only come to the court. They don't go out to all the parties, but we mark them as exhibits so all the parties can see them, and they usually look at them that day before they're offered into the evidence. So, but I think everybody does it differently. I was just curious how everybody does that. I think those are pretty much the questions that I had. Do you guys have questions for me? Yes?
Do you think an argument could be made that a denial of visits during a pivotal stage in child development for 30 days, something like that, inhibiting the bonding of that child, should be a final appealable order?
Okay. Question is whether denial of visitation during a pivotal age for a child that could prevent bonding and attachment could be a final order. Never considered that before. I don't know. That would be new and different law, I think. I don't think that that's ever happened before, but it would be a good argument. I don't know. I don't know the answer to that. I got to tell you, I don't know the answer. Does anybody else have a thought about that?
Well, it affects his potential rights.
Yeah. It does affect a substantial right. That was the comment, and I agree that it does. Not only of the child, but of the parent.
But what if it's, sorry, to put another twist on his scenario, it's conditional. So denial of visits, but if they do something, the visits can resume, i.e. they put the drug patch on, and it's clean for 2 times. But it never gone to rehab, never had any, that issue regarding substance abuse has never been addressed. It's conditional, so it's probably not final and appealable.
Okay.
It's probably not
That's true.
appealable.
If it's
But
conditional on something.
Substantial right.
The right is that that 4 weeks to get the patch on and to get the results back. I mean, you don't get that time back when you're a baby. You don't get that time back. So that's something you can't get back. That's what
I don't know the answer.
okay.
Sorry. But if you do that, if you appeal it, let me know. I want to know. I want to know the answer. Yes.
Judge, what's your position on if the permanency goal changes from reunification to adoption? Do you continue to allow visits or cease them?
If the question was whether you continue visits after the permanency goal changes from reunification to adoption. My view has been that I continue visits until we have the termination of parental rights. my concern, again, is if we don't end up terminating parental rights, or, for instance, if nobody files for termination of parental rights, but if we don't have, for some reason, termination of parental rights, what happens to that child? I mean, if they're not having visits, that's still their parent. Until it's not, that's still their parent. And so right or wrong, that's what I've been doing. Because we still have visits. We forge on. Because, and I've had it happen. I've actually had it happen where we had moved the goal toward guardianship, and then one of the parents got themselves together and ended up getting the child back during that interim period of time, and they never did file for termination of parental rights. So it was a good thing we hadn't ceased visits. So, yeah.
Well, I know the answer on my case, but had been kind of MIA and doing nothing. Termination was filed, and then they wanted to resume visits and things like that. Would you have a different view if they hadn't been having that contact?
Probably. Yes.
I know sometimes they use that then as, well, now I'm trying to
get
my life back together.
Yeah, if they had been out of the picture for a long time and had not been having visits, then I don't see that as a reason to start visits. No, but if they've been having visits all the way along up till then, I wouldn't see it as a reason to suddenly stop visits just because the goal changed. Because until you have a termination of parental rights, they still are their parents. And so I feel like it's dangerous ground to terminate visits unless there's a reason, and sometimes there's a reason. If it's harmful to that child, then for whatever reason, then I will terminate visits regardless of what the goal is, if there's a harm to the child. Other questions?
I have a question.
Yeah.
In your opinion, what things could the CASA program be doing to make juvenile court procedures run more smoothly? I'm on a CASA board, so I'm just asking, like you mentioned the bags in the courtroom. I think that's a phenomenal idea. Are there certain innovative things that you've seen that we could replicate in other jurisdictions?
Well, our CASAs, I've done a lot of CASA trainings as well, and the thing that I always tell CASAs is they have that unique ability because they usually have one child, as opposed to guardian ad litem's having multiple children that they're trying to take care of. And so I think the number one thing they can do is work real closely with the guardian ad litem. I always got real chummy with the CASAs, and they would call me and say, hey, did you know this is happening? Because they could be my eyes and ears sometimes and do a lot of groundwork that I didn't have time to do, and then I would file motions to change placements or change visits or something based on something that they had told me. The other thing is I'd have CASAs that would go visit kids in other states and things. I mean, there's just lots of things, or they would go take the kids to buy Halloween costumes or take them on picnics and things that those kids had never had anybody do for them. So those sorts of things they can do. Like I said, our CASA work was trying to set up a room in our courthouse. If there's any extra rooms in the courthouses where they could set up a room that would be kid friendly, I think that would be a great thing. Our CASA worker has even set up in McCook. Do you know Kathy McDowell in McCook? You should get to know her because she's a super CASA person. But she has set up a place in McCook in their office where they do the visits now, because she didn't like having them in the basement of a bank when it wasn't safe to do them in the home. They were doing, which was not a homey situation for a kid to be in for 5 hours in the basement of a bank. So it's like a little apartment. There's bunk beds and a room in one area, and there's a kitchen area that has laundromat kind of thing, washer and dryer and a stove. They can make a dinner, and they have a table and chairs and a TV in the other room. It's like a little apartment, a mini apartment for them to have visits in where, when they can't do them in the home. So it's really nice. And then it has a little area where there's toys and books and things like that. So things like that. But you should get to know Kathy McDowell because she can give you lots of ideas. So, other thing I will tell you is if you don't have this book by Christine Constantinos, best book on juvenile law in the world. I use it all the time. When any sort of just bizarre issue comes up in juvenile court, I've never had it not be in this book. It encompasses almost everything. Been very, very helpful to me. Judge Daniels told me about that when I first became a judge, and it's been very helpful to me. And the last thing I want to say to you is guardian items are my eyes and ears as a judge. You guys are talking to those kids and able to visit with them one-on-one. That's one of the most frustrating things to me. Since becoming a judge, when I was a guardian item, I was able to talk to those kids and visit with them, get to know them, and have them trust me and talk to me and tell me things. And I sit up there on the bench now, and I can see a child who's hurting or scared or sad, and I'll say to them, you know, anything you want to say, and I can tell that they've got a problem or something that they're worried about. But most of the time they won't talk to you. I mean, there's times that I have kids that want to say way too much, and I have to get them to stop talking. Okay, we gotta go now. But and they love to come to court, those kids. But the other ones, sometimes if they're really hurting, they won't talk to you. But I'll always say, you see that guy sitting next to you, that's your guardian ad litem. Make sure you talk to them after court and visit with them. But if you don't build that relationship with them and build that trust, they won't talk to you. So make sure that you're building that bond and getting to know that child, and because you're the one that's in their corner, the only one that they've got to talk to. And then make sure you're advocating and telling the court what they need, because we don't just instinctively know that, that's for sure. So anything else? I think I used up all your time, so I was hoping to get you out of here early, and I didn't do that.